office.
Hello, good morning everyone, and welcome to the Quasi Judicial Functions of the Sanggunian, a capacity development activity brought to you by DILG Mimaropa's Legal Office Unit. I am Chelsea Tamayo, LGOO3 from the DILG Mimaropa LGCDD, and I'll be your host for today. So before we officially start with our morning's activities, just a few reminders po for everyone. First is kindly access and log in sa ating pong attendance form. Naka-chat po yan sa ating chat box. And we'll give you the next 5 minutes po before 8:30 a.m. before we officially start to accomplish yung ating pong login form. So kindly choose login doon po sa ating options and answer po no yung ating very, very quick survey there. So thank you very much for that. Also, some other activity reminders. May we request everyone to change your username following the format flashed on your screen and also sa naka-chat po no, sa ating Zoom chat box. So just put your LGU or office and then your full name so that we may see naman po sino-sino yung mga kasama natin from all over our region this morning. And then second po, tinurn on po namin yung feature that you can unmute po your microphone. So if you want to say something po or to be addressed in the duration of our activity, kindly raise your hand po to be acknowledged and for us po to unmute po your microphone. And you may turn off your video to save your bandwidth. Pero you may leave it open naman po if mabilis-bilis po yung ating internet connection. And of course, our third reminder, yun nga pong ating very important login form that can be accessed in the link showed on your screen and also naka-chat po sa ating Zoom chat box. Okay? So we'll use the next 3 minutes po for everyone to be able to accomplish po yung ating login form. And for everyone naman po na hindi pa po nakaka-login, may we remind yung ating po mga colleagues na open na po yung ating Zoom room and pwede na po mag-login. Pero for those naman po na nagkaka-problem with internet connection and or gustong balikan no, yung ating session this morning, live po kami sa YouTube channel ng DILG Mimaropa LGCDD. So you may also like and subscribe po to be updated with other CapDev content from yours truly. So naka-chat din po yung ating YouTube link kung saan po naka-livestream tayo. Pwede po natin yan i-share sa ating ibang mga kasamahan na nahihirapan pong makalogin sa ating Zoom room. So yun lang po. Hopefully everyone's able to already answer po yung ating login form. So see you po in 2 minutes and we'll officially start with our activity. Thank you very much everyone and hopefully you're all safe in your own offices po or kung nasan man po tayo jumoin dito sa activity na to. Thank you and see you in 2 minutes. Okay po, so magandang umaga po ulit sa ating lahat. Muli ay welcome po sa ating CapDev on the Quasi Judicial Functions of the Local Sanggunian. And before we officially start our main activity, I of course will be starting with the prayer po. So everyone, may we request to put ourselves in the presence of the Lord and let's have our morning prayer.
Panginoon, kami po ay nagpupuri sa iyong kadakilaan. Muli, naririto kami, dumudulog sa iyong harapan upang hilingin ang iyong pagpapala bago namin simulan ang mga gawain sa araw na ito.
Lubos din po ang aming pagpupuri at pasasalamat para sa mga biyayang patuloy mong pinagkakaloob sa amin. Sa kalakasan ng katawan, sa kasaganaan ng mundo, sa katalinuhan ng isipan, at sa pangakong buhay na walang hanggan.
Maraming salamat po sa panibagong araw na ipinagkaloob mo sa amin upang patuloy naming magampanan ang aming tungkulin sa loob at labas ng aming tahanan at sa bawat mamamayan na aming pinaglilingkuran.
Patawarin mo rin po kami sa aming mga pagkakasala, kalabisan at sa aming mga pagkukulang, dala ng makamundong kaginhawahan.
Ganun pa man, patuloy pa rin po kaming nananalangin upang kami ay iyong gabayan, kasabay ang kahilingan na iluyo mo kami sa mga tukso na maaaring magsadlak sa amin sa pagkakasala.
Kami ay nagsusumamo na maligtas sa lahat ng uri ng sakuna at mga karamdaman, lalo na sa COVID-19 na bumawi na ng maraming buhay at patuloy nating nilalabanan.
Isinasamo rin namin na huwag mong pabayaan ang mga frontliners na patuloy na nagsisilbi para sa iyong mahal na bayan.
Pagalingin mo po nawa ang mga may sakit at aliwin mo ang mga puso ng mga taong naulila at nagdadalamhati.
Buhayin mo po sa aming mga puso ang tunay na diwa ng pagmamahal upang ito ay magbunsod sa amin ng tunay na paglilingkod ayon sa iyong kalooban.
Ang lahat pong ito ay aming hinihiling at idinadalangin sa banal mong pangalan.
Amen.
Ang pambansang awit ng Pilipinas.
Kayang magiliw, pero sa sinakanan, alam ng puso, sa titik mo'y buhay. Lupang hinirang, tuyagan ang magiting, sa mandulupin, di ka pasisingil, sa nagatak tutok sa simoy at sa langit mo pagaw, ay hinatak tudlan, awit sa pagkayang minamahal, ang isang ng matawad mo'y tagumpay na nagtihindig, makituwin at araw niya kailan, ang ay di magtitindig, exercise the sorrow for your growing family who are to reach the waiting glory. We share the love this world to reach and be of our home. Be of our realizing dreams. A haven for all the living soul. Higher for the world to see. How great your hands are given with you. To our hearts belong. Be of our brightly shining home. A destination of toys, a place to find how all the dreams come true. We Malupa, realizing dreams, a haven for all the living soul, higher for the world to see. How great your eyes are giving with you, to our hearts belong. We Malupa, glowing and shining. We Malupa, the destination of choice.
Okay, again, magandang umaga po sa ating lahat and welcome to the capacity development on the quasi-judicial functions of the Sanggunian. Ako po ulit si Chelsea Colleen Tamayo, LGOO3 from DILG Mimaropa, and I'll be facilitating our session this morning. So before po we officially na talaga start our activities, just a few reminders, especially po doon sa ating mga kakapasok pa lang po na participants. So first po is, of course, we want to see sino po yung aming mga kasama this morning. So we request everyone to change your username following the format flashed on your screen and also naka-chat po sa ating chat box. So just put your LGU and or office following your full name. And then second po, just a heads up to everyone to prevent po distractions during our session. We uncheck ko lang po, no? So our participants at the moment can't unmute themselves. So at any time po during our discussions, you may raise your hand or chat po in our Zoom chat box to be acknowledged so that we may unmute po your microphone if you want to verbally share something. You may also turn off your video to save bandwidth, but it would also be nice po, no, to see your beautiful faces here with us today. And then third po, and the most important one is we request everyone to accomplish yung atin pong required login form, which can be accessed in the link flashed on your screen and also naka-chat po sa ating Zoom chat box. We're also live po sa ating DILG Mimaropa LGCDD official YouTube account. So you may watch it po again, no? Or share the live streamed video even after our activity is over. So don't forget lang po to like and subscribe our official channel so you will be able to be updated with the latest and greatest CapDev content from yours truly. So before po tayo mag-start, of course, gusto naman po nating bigyan pagpupuri or to acknowledge po and appreciate the participants that are with us here today. So our activity po is for specifically for our 10 target LGUs, but we're also acknowledging po, no, and very welcome po yung ibang ating mga LGUs from all over Mimaropa who are able to join us. So our CapDev for this morning are for our vice mayors po, no, ating mga kapitapitanang vice mayors, ating mga SB members, ating mga ex-officio or sectoral representatives po sa ating Sanggunian, at of course sa ating pong mga warriors on the ground sa ating DILG, ang ating pong mga MLGOOs. So first po, you may chat po, no, yung inyong pagbati sa ating Zoom chat box or use the emote or reactions feature to signify po your presence. So first po from Buwak, Marinduque, pinapangunahan po yan ni Vice Mayor Honorable Sonny L. Paglinawan. Magandang umaga po sa ating mga taga Buwak, Marinduque. Good morning, good morning. Hope you're all safe and sound po. Ayan, may mga papuso na po tayong natatanggap. Maraming salamat po. Of course, we also have Santa Cruz, Marinduque. Yan po ay kasama po natin si Vice Mayor Honorable Geraldine M. Del Rosario. Good morning po sa mga taga Santa Cruz. Ayan, may mga papuso po ulit. Maraming salamat po. Sunod naman po ay galing po ng bayan ng Luok, Occidental Mindoro, headed by Vice Mayor, or here with us today, Vice Mayor Honorable Marlon V. De La Torre. Good morning po. Magandang umaga sa ating mga taga-Luok, Occidental Mindoro. Another one po from Occidental Mindoro ay ang bayan ng Lubang. Kasama po natin and their representatives, si Vice Mayor Honorable Charles Z. Villas. Magandang umaga po. Ayan, magandang umaga po sa ating lahat. Dumako naman po tayo sa Oriental Mindoro. Diyan po ang bayan ng Bulalakaw. And here with us, with his SB members po, no, si Vice Mayor Honorable Ramon G. Magbanwa. Good morning po. Okay po, sunod naman po ay ang bayan ng Mansalay from Oriental Mindoro pa rin. Kasama po natin dyan si Vice Mayor Honorable Lynette G. Postma. Good morning po sa mga taga-bayan po ng Mansalay. Okay. And we also have from Balabac, Palawan po, kasama po natin dyan si Vice Mayor Honorable Alhazni A. Astami. Magandang umaga po. And we also have from Kalayaan, Palawan po, si Honorable Hermoso A. Ornopia. Ayan, maaga pong nag-login kanina si Vice Mayor. Good morning po sa mga taga-Kalayaan. Ayan. Dako naman po tayo sa Romblon. So magandang umaga po sa mga kahidyokan Romblon. Kasama po natin si Vice Mayor Honorable Kenyo R. Rabino. Magandang umaga po. Good morning. And huli po no, sa ating target LGUs ay nandyan po ang bayan ng San Andres Romblon. Kasama po natin dyan si Vice Mayor Honorable Joel G. Ebanez. Good morning po. Okay. And of course po, no, shout out din po sa lahat po ng ating mga bayan and LGUs na talaga pong gustong matuto sa ating topic ngayong umaga at jumoin po sa atin, whether it may be dito po sa ating Zoom room or sa ating nanonood po using our YouTube live streaming. So in general po, no, sa mga taga Marinduque po, good morning po sa ating lahat, sa lahat po ng ating, ayun po, may mga taga Buena Vista po tayong kasama. Tagamog po, good morning po. Okay, maraming salamat po sa pagdalo po, no, sa ating programa. Sunod naman po ating mga taga-Occidental Mindoro, kung meron po tayong mga ibang LGUs po, no, na jumoin. Ayun, may Gasan Marinduque din po. Good morning po. Ayan, magandang umaga po. Sa atin po mga taga-Oriental Mindoro naman po, baka po may mga iba po tayong participants from Ormin na dumalo po sa ating activity today. Good morning po sa ating lahat. And sa mga taga-Palawan din naman po, no, na jumoin po. Good morning. And of course, sa mga taga-Romblon po, magandang umaga po talaga sa ating lahat ng mga participants. We appreciate your presence po, no, sa ating pagtitipon ngayong umaga. And okay, so para naman po mabigyan tayo ng konting inspirasyon para po sa pagsisimula ng ating activity ay nandito rin po, no, ang aming kapitapitagan din at napakamahusay na Regional Director R.D. Wilhelm M. Suico para naman po bigyan tayo ng kanyang opening remarks. Good morning po, R.D. Will.
Yan. Magandang umaga. Sa ating lahat. Akala ko hindi nyo ako i-unmute. Chelsea.
Ay, na-unmute na po, RD.
Good morning, everyone. I welcome you this morning on today's event of CapDev on Quasi Judicial Functions of the Sanggunian. Ano ba ibig sabihin ng CapDev? Baka tayo lang sa DILG nakakaintindihan ng CapDev. Dapat ipaalala natin is CapDev is short for capacity development, no? Palagi natin ipaalala because of course LGUs are already capacitated, but of course as we go along, we as part of the mandate of the DIL is to develop the capacity of the local government units, the capacity of their officials. under those who are in charge of the different functions of the local government units, whether executive or legislative. Magandang umaga again, nakita ating mga vice mayor. Mga vice mayors natin, ang ating mga member ng mga sangguniang mga sangguniang bayan, andiyan po. Nakakatuwa po, naka-group viewing kayo. Ikita ko po rito. So hindi ko na po babanggitin isa't isa, nabanggit na po ni Binibining Chelsea kanina, ay na-acknowledge na po yung ating mga mga leaders ng ating mga sanggunian. Of course, as full devolution promulgated by Executive Order 138 is now at full swing, nakikita po ng DILG that it is critical that our LGUs are constantly capacitated. Sinabi ko na, capacitated in terms of knowledge, skills, and abilities that are required them to be competent and capable public officials. After all, sabi nga, dun sa Spider-Man movie, great powers comes with great responsibility. So, with the expected increase in responsibilities and authority to be devolved into the local government units, it is important that we have a higher level of fundamental awareness, not just fundamental, not just the standard level, but a higher level on awareness on the binding laws and anchored to respective positions. It doesn't mean na pag na-devolve na po ang karamihan ng mga services because to be effective next year because of the implementation of the Mandanas ruling of the Supreme Court. So, in short, it is giving more money, resources, and powers to the local government units. But it doesn't mean that hindi na po kikilalanin ng local government units natin ang mga batas ng ating pong national legislature na ginawa po sa ating national legislature. So ano ba ibig sabihin ng quasi-judicial power? So it refers to incidental power of the Sangguniang Panlunsod, meaning ano ibig sabihin ng incidental? Yung isasabing na kaakibat, no? Incidental power, incidental of the Sangguniang Bayan or Sangguniang Panlunsod or Sangguniang Panlalawigan to hear and determine controversies outside of its legislative duty or power. So what is the main power or duty of the legislative or legislature? Siyempre, ang gumawa po ng batas, but ito po ang ating pong mga sanggunian ay binigyan po under our law, under the local government code, to hear and determine or ascertain facts and decide cases by the application of the rules of the law in the enforcement and administration of justice. Hindi po ibig sabihin na yun po ay minsan ay nagkakamali, no? O yung mga baguhan, akala nila yung power nila is the power to summon people in the localities and to grill them, no? Yung gabi na kagalitan, ganun. Kaya nga si Pangulong Duterte ay galit na ayaw niyang tawag do bastusin yung mga opisyalis niya doon sa Senado or Kongreso. Bigyan naman po sila ng dignidad at pagkonting paggalang. Let me share you a story. No? When I was 24, o legal officer po ako ng DILG Region 9. No? So the Sangguniang Panlunsod of Zamboanga City, ang ano pa noon, ang vice mayor or the presiding officer was the present mayor now, the Beng Climaco, no? So they wanted to have a DILG clarify in one of their sessions, clarify matters on operation of ano ba yun, cockfighting, ganun, something, hindi ko na matandaan. So they sent me a letter sa pro forma letter yun na ginagamit nila sa kanilang mga department heads o sino man doon, not even department heads but even ordinary citizens na gusto nilang pa-appear before the Sanggunian. So it said that doon sa pro forma, blank-blank ganun. Mr. You are hereby directed directed to appear before the session of the Sangguniang Pananawigan, etc., on this particular date to give your side or opinion on the operation of this and that and that. Sabi ko, wow, binibigyan ako ng summon ng Sangguniang Panglungsod. Okay, just to say, I appeared, but before I started dwelling on the subject matter, sabi ko sa kanila in front of them, ito yung mga Sangguniang Panglungsod, highly urbanized city councilors, ito yung mga abogado, no? And, sabi ko sa kanila before, with due respect, gentlemen and ladies, you could have called me up. Nagkapitbahay lang tayo. And you cannot even summon the department or the office that supervises you. Ganun. You could have invited us in a nice way. Hindi kasi nag-sorry lahat yung mga nag-sorry yung vice presiding officer, yung mga councilor, hindi nila then realized that they have no power to summon or to forcibly summon and castigate a member and a representative of national government agency, particularly the DILG, of course. So that's one tip, no? Okay. This activity serves as a refresher course and aims to capacitate the Sanggunian in the exercise of its quasi-judicial powers. Quasi, no? Additional, yung parang judicial powers, especially the procedural and substantial aspect. So it is expected that upon conclusion of today's capacity development, we hope that the participants will be equipped with a deeper understanding regarding their obligations and to act this with utmost integrity. We all know that public office is a public trust, and I am certain that everyone here today is constantly guided by that principle. Despite this being said, there are still possible instances when some of us may have gone beyond the limits of authority and have not been diligent enough in fulfilling their duties as public officials, such violations are deterrent to our constituents and most importantly, the state. That is why one of the agendas to be discussed today are the disciplinary actions for elected officials. Kahapon, we have been meeting with Secretary Anyo and some all officials of the department. Napag-usapan namin ang mangyayari pag nagkataon na nagsimula na yung kampanya. No? Magulo ito. Kasi magkakaroon po ito ng kasi different status qualifications sa every local government unit, every local bayan, local legislation. So magkakaroon to, may mga limitations, gagawa ata ang COMELEC, no? May mga limitations sa pagpasok ng mga candidate sa kada bayan o kung ang kada bayan o kung ang tinatakbuang posisyon ang nangangapa niya ay for national position o kada rehiyon. So magkakaroon na po rito ng I raise this up na baka magkaroon ito ng pagkakataon na abusuhin ng mga officials ang kanilang power to impose lockdowns. Kasi darating to si kandidato o partido kabila papasok, so we have to meron silang schedule, so we have to impose stricter lockdowns here. We will ask the RITF to allow us to issue lockdown. So same thing, ganun din ang mangyayari, magganunan. So I raised that possibility, that scenario, and the government will be doing. Sabi ko, baka magkakaroon na ng uniform guidelines when it comes to inter-zonal or border crossings of the campaigners and candidates during the election period. So again, review on the grounds to discipline local officials. Yan, of course, number one, disloyalty to the republic. Okay, disloyalty ka, meaning example, alam na natin to, nag-aid ka, you're giving aid to the you're giving information, security information sa ibang bansa. Where you are elected official of the Philippines. So mga trade secrets natin, mga ganun, Then another is culpable violation of the Constitution. Maraming mga batas po sa Constitution na dapat pong sundan po ng ating po mga local elected officials and national elected officials as well. So again, dishonesty, oppression, misconduct in office. Ano ba yung mga misconduct na sa office? Tulad yung nakakaya naman, elected official ka, kagalang-galang, honorable. Tapos yung sa misconduct na hindi dapat conducts na hindi dapat ginagawa ng isang halal na opisyal ng pamahalaan. Another is negligence or dereliction of duty. Elected ka na bokal, tapos hindi mo naman ginagawa ang iyong tuntunin, no? So, commission of any offense involving moral turpitude, kadalasan dito yung mga illegitimate relationships, not legit, no? Yung mga pangangaliwa, if you are married. Then of course, itong abuse of authority, ito yung unauthorized absences. 3 sessions if you are absent without the proper authorization, it could be grounds for disciplinary actions, acquisition of citizenship, and among others. So ito ay mapabalikan po natin mamaya. So as we go through today's relevant discussions and gain further understandings of several provisions under the Local Government Code, may we be reminded of our sworn oath to exercise our duties as accountable public officials with due diligence and impartiality. Together, let us continuously capacitate ourselves and be advocates of good governance, peace, and security. Mabuhay tayong lahat.
Okay, thank you very much, RD Will. And isa naman pong masigabong virtual clap para po sa isang mahusay po na mensahe ng ating regional director. So, thank you po, RD, for shedding light sa relevance and timeliness po ng ating capacity development na gagawin ngayong umaga. Thank you po very much, RD. And before we further continue po sa ating activity, may we request everyone to briefly open lang po yung ating cameras and videos para naman po makapag-take tayo ng photo opportunity to document this activity. So, requesting lang po everyone. Okay. All right. So I see some of us have changed our Zoom background. Thank you very much. Ayan. So smile lang po tayo. Meron tayong 3 pages. So sa ating pong secretariat. For page 1, 1, 2, 3, smile. Okay. For page 2. And lastly, page 3. Okay, maraming salamat po. Kitang-kita po natin ang mga nagagandahan at nagagwapuhan nating mga participants. Ngayon naman po, para naman po bigyan tayo ng mas context pa doon po sa ating magiging activities for the day, ay, teka lang po, we'll just hold on po. Ayan. Okay. Para po mas bigyan tayo ng context, so na-mention na po ni RD no, na at the end of this activity or our CapDev, Capacity Development session for this morning, we are expected to have a deeper understanding regarding the obligations of the Sanggunian to act with utmost, no, very emphasized po yung utmost, impartiality, integrity, and most especially yung observance po ng due process of law in adjudicating administrative cases involving local elective officials. And ang atin pong main objective for our 3-hour session is to reorient and capacitate the Sanggunian in the exercise of its quasi-judicial powers as provided by the local government code. So meron po tayong 3 main topics for this morning. Una po dyan ay the local Sanggunian as a quasi-judicial body. Second po would be the disciplinary actions for elective officials. And third po ay yung ating discussion on the administrative hearing proper. So without further ado, we'll move on na po sa ating unang module. So next slide, please. Ayan. So para po mas malinawan tayo, no? Ano nga ba ang papel ng local Sanggunian as a quasi-judicial body? Nandito po ang ating napakamahusay din na legal committee member of the DILG Mimaropa, Attorney Irvin L. Palangka, to deliver us our first session. Good morning po, Attorney Irvin.
Yan. Good morning, Ma'am Chelsea. Okay po ba yung audio ko? Naririnig po ba? Clear
Yes
naman
po,
po ba?
very clear po, sir.
Ayan. So, pa-share na lang po ng ating PowerPoint. So, I think okay na po tayo. To our Regional Director, RD Willie, ating pong Assistant Regional Director, ARD Ray, sa ating pong mga regional office employees, ating provincial offices, sa ating pong mga target LGU participants po, at ano na rin po sa atin na rin pong mga field officers, at sa lahat po ng ating mga participants ngayon, magandang umaga po. Ako po si Attorney Irvin Palangka, and magdi-discuss po ako today ng first part ng ating capacity development on the general overview po ng local Sanggunian as a quasi-judicial body. So I hope that this lecture po will give you an additional knowledge or refresher knowledge on the quasi-judicial powers po ng ating mga local Sanggunian. So for questions po, i-chat nyo lang po ito sa ating mga ating chat box, at sasagutin po natin yan sa ating Q&A portion po mamaya. So next slide po, ma'am. So for the basic principles po, all levels of Sanggunian except the Sangguniang Barangay are invested with dual functions, namely, first, legislative function, and second, quasi-judicial functions. So alam naman po natin sa ating Sanggunian na ang ating primary function is to legislate, or meaning tayo po ay tagagawa ng ating mga ordinances or resolutions para po sa general welfare ng ating community. And second po, ito po yung hindi masyadong alam ng ating mga kababayan na ang ating mga local Sanggunian ay mayroong quasi-judicial functions. So next slide po, ma'am. Ngayon po, aalamin natin kung ano po yung difference ng legislative at quasi-judicial function. First, sa ating pong legislative function, it is the power of the local Sanggunians to enact rules and regulations which may be embodied in the form of an ordinance or resolution of local application and having the force and effect of law. So ito po yung ating rule-making power sa Sanggunian. On the other hand, quasi-judicial function is the discretion of the officers who are required to investigate facts or ascertain the existence of facts for the purpose of drawing conclusions to be used as basis for an action or to exercise discretion of judicial nature. Meaning ito po yung ating power to hear and decide admin cases filed against erring elective local officials. So as a quasi-judicial body, as Sanggunian is an organ of the government other than a court and other than a legislature. It affects the rights of the private parties through either adjudication or rulemaking. So, ang primarily po na nag-grant ng quasi-judicial power sa ating mga local sanggunian ay no other than that yung ating pong Local Government Code of 1991. So, ito po yung ating primary legal basis sa ating quasi-judicial functions as sanggunian. So, next slide po, ma'am. So, reason for grant of quasi-judicial powers. Bakit po meron tayong quasi-judicial powers ang ating mga sanggunian? So, the grant of quasi-judicial powers is justified by the expediency or the need of the government to respond swiftly and competently to the pressing problems of the modern world. Ito po ay para mapabilis yung ating mga administrative cases filed against erring local elective officials. Kesa po idiretso po ito sa korte na yung court ay hindi naman po nila expertise masyado ang ating local government code, ay ibinigay po ito ng local government code sa ating mga sanggunian para mabawasan po yung load ng ating mga court. Kaya po meron tayong quasi-judicial power na ibinigay sa ating mga local sanggunian. So dahil din po yan na ang ating mga local sanggunian ay merong expertise on the knowledge po sa ating sa local governance para po magkaroon ng speedy disposition ng ating mga administrative cases on the sanggunian level pa lang, at hindi na po siya mapunta sa ating mga court. So yun po yung ating reason for quasi-judicial power. Next slide po. So quasi-judicial powers includes the following powers. First is the power to prescribe the rules and procedures. Second, the subpoena power. Third, and the contempt power. So sa first power po natin, yung to prescribe rules and procedures, it is already incidental po sa power ng sanggunian vested with quasi-judicial powers na magkaroon po tayo ng rules of procedures sa ating mga administrative cases na i-file sa ating mga respective sanggunians. Ang rules and procedures po natin, ito po yung mag-guide sa atin kung ano po yung mga palatuntunan na dapat nating sundin kapag mayroon pong mga isinampang kaso sa ating mga local elective officials. So, as a consequence, having quasi-judicial powers, it is necessary that the sanggunian must promulgate their rules of procedures in hearing administrative cases po para sa mga erring local elective officials. Para na rin po ito to maka-avoid ng kaguluhan sa ating mga sa proseso ng ating mga hearings, at para na rin po magkaroon tayo ng speedy disposition ng ating mga cases. So sa next power po, next slide. Subpoena power. So what is a subpoena power? The power to issue subpoena ad testificandum and subpoena duces tecum is not inherent in administrative body, and it may only be exercised if allowed by law and only in connection with the matter to which they are authorized to investigate. So as a rule, the power to issue subpoena is not inherent, exception if it is allowed by our law. So alamin po natin kung meron po bang subpoena power ang ating mga local sanggunians under the local government code. Next slide po, ma'am. So does the local sanggunians have the power to issue subpoena? Meron po ba tayong mga idea kung meron po bang power to issue subpoena ang ating mga local sanggunian? So ang sagot po natin dyan ay, next slide po, ma'am. Yan, ang sagot po ay yes. So, bakit po merong power to issue subpoena ang ating mga local sanggunian? So, next slide po. Yan, on the basis po ng ating local government code under section 65 on the rights of the respondent, the sanggunian can compel the appearance of any person pursuant to its subpoena powers. So pwede pong mag-compel ang ating sanggunian in case na meron po tayong administrative case na hini-hear. Ayan, pwede po tayong magpasubpoena. Or meaning, i-compel po natin yung attendance ng isang tao para maging witness po siya or mag-testify po siya doon sa ating administrative hearing. Also, the Sanggunian can require the production of documentary evidence o yung tinatawag po nating subpoena duces tecum. So, aside from power to compel the attendance of any person, pwede po tayong mag-require na i-produce yung isang documentary evidence or any other papers na relevant po sa ating hinihear na kaso. So meron pong subpoena powers ang ating local sanggunian under this section 65 po. So next slide po. So another power po, yung contempt power. So what is contempt power? It is essentially a judicial power and not inherent in administrative bodies. It must be expressly granted and must be used only in the exercise of quasi-judicial functions. So ang contempt power po natin ay mainly judicial power lang po siya. Hindi po siya hindi po siya ginagrant sa mga administrative bodies, except kapag meron na lang pong express provision na ating batas na nag-grant po ng contempt power sa isang sa isang body or tribunal. So next slide po, ma'am. So what is a contempt? Contempt is a defiance of the authority, justice, or dignity of the court which tends to bring the authority and administration of law into disrespect or to interfere with or prejudice party litigants or their witnesses during litigation. So sa madaling salita po, ang contempt ay yung pag-disrespect po doon sa ating mga quasi-judicial body. So ang contempt po ay merong direct or indirect. Yung direct po, yan po yung kinukumit within the presence po ng ating quasi-judicial body. On the other hand, yung indirect contempt naman po, ito ay kinukumit outside po outside the presence of the quasi-judicial body. So yun po. Next slide, ma'am. So ito po question. Can the Sanggunian, in the exercise of its quasi-judicial powers, cite any person in contempt? So ano pong idea natin dyan? Meron po ba tayong power to cite any person in contempt in the exercise of our quasi-judicial powers? So ang sagot po dyan ay no. So bakit po hindi tayo pwedeng mag-cite any person for contempt while in the exercise of our quasi-judicial powers in the local Sanggunian? So next slide po, ma'am. So based po sa ating DILG opinion, that Sanggunians cannot punish any person in contempt, but it cannot invoke the aid of the regional trial court to cite the defiant person in contempt pursuant to Rule 75 of the Rules of Court. So based po sa sinabi ko kanina, ang contempt power ay mainly judicial power, except ginagrant lang po ito kapag may express provision ng ating batas. So kapag binasa po natin ang ating local government code, wala naman po tayong makikita na nag-grant ng contempt power sa ating mga local government sanggunian. So kaya po meron tayong DILG opinion na nagsasabi na ang sanggunian ay hindi pwedeng mag-punish ng contempt sa isang tao. However, hindi naman po tayo walang solusyon para i-cite yung isang tao sa contempt. Pwede po natin hingan ang tulong ng ating mga regional trial courts by filing an appropriate pleading po para i-cite po yung ating defiant person in contempt. So yun po, clear na po sa atin yan. Wala po tayong contempt power sa ating local sanggunian. So next slide po. So requisites for proper exercise of judicial powers. So before po natin i-exercise ang quasi-judicial powers, kailangan po nating makumpleto itong tatlong ito. Dahil kung wala po itong tatlong ito, ay baka po magkaroon ng problema yung ating quasi-judicial body sa pag-hear po ng ating mga administrative cases. Unang-una na po dyan ang jurisdiction. Kailangan po meron tayong jurisdiction sa ating pag-exercise ng quasi-judicial power. Second, notice. Ito po yung sinasabi nating due process or yung dito po yung binibigay yung right to know, right of knowledge po ng respondent doon sa mga allegations or charges filed against him or her. So next po, yung ating last ay yung hearing. Ito po yung the right to present your evidence and to examine the witnesses po na pinipresent natin doon sa administrative hearing. So iisa-isahin po natin yan dito sa ating mga next slides. So what is jurisdiction? Jurisdiction means the power or the capacity conferred by constitution or by law to a court or tribunal to entertain, hear, and determine certain controversies and render judgment thereon. So jurisdiction, ito po yung nagdedikta kung ano yung dapat na i-hear ng isang sanggunian na naglalabag po sa mga batas ng ating mga naglalabag na local elective officials po natin sa ating mga palatuntunin at mga batas. So ang jurisdiction po ay madidetermine natin kung ano po yung mga naka-allege sa complaint, as well as the character of the relief sought or yung prayer po ng complaint. For example, meron pong i-file sa ating complaint against a certain elective official, doon po natin malalaman kung ano po yung jurisdiction ng ating, kung meron po tayong jurisdiction over that complaint. Kung makikita po natin doon ay, for example, may ground po siya na misbehavior, so masasabi po natin mayroong jurisdiction yung ating sanggunian dahil meron po tayong powers to hear administrative cases over that said ground. So next slide po, ma'am. So sa atin pong aspects of jurisdiction. So first aspect po natin is the jurisdiction over the subject matter. It is referred to as the power of a particular court or a tribunal or a quasi-judicial body to hear the type of case that is then before it. The term also refers to as the jurisdiction of the court or the tribunal over the class of cases to which a particular case belongs. So ito po yung sinasabi ko na depende po sa subject matter na doon po natin madidetermine kung meron pong jurisdiction ng ating local sanggunian. Dito po ay makikita natin yung nature of the cause of action and the relief sought. So doon po natin i-base yun kung meron tayong jurisdiction over the subject matter. So next slide po. So yan, jurisdiction over the subject matter, it is conferred by law. Meaning ito po ay idinidikta ng ating batas. Yan po ay lalong-lalo na po na ang ating jurisdiction sa ating local sanggunian ay mentioned po ng ating local government code. As it is conferred by law, it cannot be granted by the agreement of the parties. Meaning hindi po natin ito pwedeng hindi pwedeng pag-usapan ng partido kung ano yung magiging jurisdiction nila. Pangalawa, it cannot be acquired, waived, enlarged, or diminished by any act or omission of the parties. So bawal po nating idagdagan or bawasan yung jurisdiction which is conferred by law. And lastly, it cannot be conferred by the acquiescence of the courts. Meaning, hindi po ito maaaring payagan lang basta-basta ng isang tribunal or body. Meaning, kapag given po na walang jurisdiction over the subject matter ang quasi-judicial body, tapos inaccept ng ang ating local sanggunian yung case na yon which na wala naman pala tayong jurisdiction, ay hindi po yun karapat-dapat gawin at yun po ay labag sa ating batas. So next slide po. So another aspect po of jurisdiction is jurisdiction over the person of the petitioner or the plaintiff. Ito po, paano po natin ma-acquire yung jurisdiction over doon sa nag-complain? So, ang sagot po dyan, it is acquired by the filing of the initiatory pleading and paying the required docket or filing fees. Usually, ito po yung the moment po na nag-file na yung complainant sa ating local sanggunian ng kanilang complaint, which is on the required form, meaning ito po ay dapat na verified complaint, ay magkakaroon na po tayo ng jurisdiction over the person of the complainant po. And usually po ay kasama nung pag-file ng complaint ay may may kasama ding payment ng required filing fees or docket fees. At ito naman pong mga filing fees or docket fees na ito, depende po ito sa ating rules of procedures po ng ating mga respective sanggunians. Whether ang ating mga respective sanggunians ay merong mga required fees, ay yun po ay part po ng pag-determine ng ating jurisdiction over the person. Kung wala naman po, ay sufficient na yung ating yung pag-file po ng complainant ng initiatory pleading. So next slide po. Another aspect is jurisdiction over the person of the respondent or the defendant. So kanina po, paano natin na-acquire yung jurisdiction ng complainant? Ngayon naman po, paano natin ma-acquire yung jurisdiction over doon sa inireklamong local elected officials? So ang sagot po dyan is it is acquired by the service of summons or by his voluntary submission to the court. So ayan po, kapag na-serve na po sa ating defendant personally, yung ating summons, ay ma-acquire na po natin yung jurisdiction over him or her. Or other than that, sabihin na po natin hindi niya natanggap yung summons, pero aware po siya na may case na na-file sa kanya at nagsulat po siya ng sagot over the allegations against him, ay makukonsider din po natin meron na rin tayong jurisdiction over the respondent or the defendant. So yan po, next slide. So jurisdiction is also limited in quasi-judicial agencies. An administrative body could wield only such powers as are specifically granted to it by its enabling statutes. Its jurisdiction is interpreted strictissimi juris. So usually, ang ating pong jurisdiction ay limited lang kung ano yung jurisdiction na nakalagay sa ating batas or sa ating local government code. Kung hindi po naka-mention na meron tayong jurisdiction over that particular case or particular issue, ay wala po tayong jurisdiction dyan. At yung jurisdiction natin ay may interpret strictly against that law. So kung ano lang po yung naka-mention, yun lang po yung ating susundin or ating papakinggan. So next slide po. So ito na po. Sa ating local government code, matatagpuan natin kung saan naka-mention yung jurisdiction ng ating mga local sanggunians, especially in disciplinary cases against elective public officials. So yan po ay naka-mention sa ating section 61 ng local government code. Ang mga may jurisdictions po dyan ay ang ating sangguniang panglungsod or sangguniang bayan, sangguniang panglalawigan, or Office of the President. So yan, sila po ang mga nabigyan ng quasi-judicial powers ng ating local government code. So hindi ko na po muna ito i-discuss masyado dahil i-discuss po ito ng ating next lecturer. So next slide po. So administrative due process. So another important requisite po ng ating pag-exercise ng quasi-judicial powers. Dito na po nagfo-fall ang ating notice and hearing. So administrative due process, or the essence of due process in an administrative proceedings, is the opportunity to explain one side or seek a reconsideration of the action or ruling complained of, and to submit any evidence a party may have in support of his defense. So sa madaling salita, ang ating administrative due process is the opportunity to be heard before the judgment is rendered. So ito po ay importante sa isang respondent or defendant sa isang administrative case. Importante na meron siyang opportunity na mapakinggan at i-defend yung kanyang sarili sa mga alegasyon na isinampalaban sa kanya before po magkaroon ng judgment yung ating mga local sanggunian sa administrative case. So next slide po. So the observance of due process. So paano po natin ma-observe ang due process as a quasi-judicial body sa ating mga sanggunian? So requisites, first, the respondent's right to a hearing, which includes the right to present one's case and submit supporting evidence, must be observed. So yan, dapat po magkaroon tayo ng hearing sa ating mga local sanggunian in case meron po tayong mga administrative cases. Hearing meaning the defendant can present his case or his defense and submit his evidence to support his claims naman. So next requisite is that the tribunal must consider the evidence presented. So tandaan po natin na kapag may ipresenta pong evidence sa ating hearing is that the local sanggunian must consider it. Pero not necessarily consider it agad-agad. Dapat po nating tignan muna yung bigat ng evidence. So i-discuss po natin yan mamaya kung ano yung dapat na evidence na i-present sa atin. So third, the decision must have some basis to support itself. Of course, this is important. Ang dapat ng sa isang sanggunian na kapag magde-decide na po tayo ng isang administrative case, ay dapat meron po tayong sufficient and legal basis para po maunawaan nung defendant or nung complainant yung naging desisyon natin sa mga complaints na i-file. So fourth po, there must be a substantial evidence. Ayun, yung substantial evidence, ito po yung required evidence sa ating administrative case. I will discuss it po sa ating mga susunod na slides. And fifth po is that fifth requisite po is that the decision must be rendered on evidence presented or at least contained in the record and disclosed to the parties affected. So yung mga evidence na i-consider po natin, yun po yung dapat nating i-consider yun po yung dapat nating i-consider in determining what decision po ng ating local sanggunians. So next requisite, in arriving at the decision, the tribunal must have acted on its own consideration of the law and the facts of the controversy and must not have simply accepted the views of the subordinate. So yun nga po, importante na ang ating decision ay merong basis sa law at hindi lang kung ano yung naririnig natin na sabi-sabi ng iba dyan. So last requisite is that the decision must be rendered in such a manner that the respondents would know the reasons for it and the various issues involved. So yun po, importante po na sa ating decision ay maisagot natin yung mga issues na iniraise doon sa complaint at magkaroon po ng sufficient basis para po maintindihan talaga ng complainant or ng defendant kung ano yung naging desisyon ng ating mga local sanggunian. So yan po yung ating mga requisites for observance of due process. So next slide po. So ano po ba ang effect if hindi natin nasunod yung mga principles of due process sa ating administrative proceedings? Ang sagot po dyan is that any judgment or order issued in such administrative proceedings is null and void and can be attacked only in any appropriate proceedings. So yun, kung hindi po natin i-observe yung principles of due process sa ating mga administrative proceedings, makukonsidered pong null and void yung ating proceedings or meaning magiging walang bisa po yun. So para po ma-declare yun na walang bisa, kailangan lang po itong i-attack or i-appeal sa higher quasi-judicial body or tribunal para po ma-declare na yung pag-akto ng ating mga local sanggunians ay in violations of the due process clause po ng ating constitution. So yun po, importante po ang ating due process, kaya dapat po nating sundin yung mga cardinal principles po ng ating due process clause. So next slide po. So what is the quantum of proof in administrative proceedings? Meaning ano po ba yung required burden of evidence na kailangang i-present sa ating administrative proceedings? So as a quasi-judicial body, ang required evidence po ay only substantial evidence. This is different po sa ating degree of evidence na required sa criminal case, which is proof beyond reasonable doubt. And iba rin po ito sa ating degree of quantum of evidence para sa ating mga civil cases, which is preponderance of evidence. Kasi ang pinakamabigat po dito na quantum of evidence ay yung sa criminal case, which is proof beyond reasonable doubt. At dito po sa ating administrative proceedings, ang required lamang po ay ang substantial evidence or such relevant evidence that a reasonable mind might accept as adequate to support a conclusion. So yan po ay defined ng ating rules of court under Rule 134 Section 6. So ano nga ba yung substantial evidence? Ito yung evidence na masasabi mo na based on the papers and other evidence presented from the complainant and to the defense, ay meron kang nakikitang naging violation or naging ground para sa administrative case ng isang local elected officials. And that without being biased or partial, meaning hindi ka nakikinig sa mga sabi-sabi ng iba. Ito ay dapat based doon sa iyong mga nakita or napag-aralan doon sa records ng administrative case. So yan po yung required evidence natin sa isang administrative case. Hindi po proof beyond reasonable doubt dahil hindi naman po ito criminal case. Hindi rin naman po preponderance of evidence, meaning kung ano po yung may mabigat na evidence na na-present, kundi substantial evidence po. Yun lamang po yung relevant evidence that a reasonable mind might accept as adequate to support a conclusion. So yun po. Next slide, ma'am. So dito naman po sa ating liberal application of rules. So as a quasi-judicial bodies, the local sanggunians are governed by the rules that we have to follow. So let us know some rules which can be literally applied by the sanggunian in their administrative proceedings. First po dyan ay administrative bodies should not be strictly bound by the technical rules of procedures. So ano pong ibig sabihin yan? Meron po tayong given set of rules of procedures. That rules of procedures is meant to be followed by the sanggunian. However, in some circumstances, meron po tayong talaga namang reasonable grounds to excuse or not to strictly follow yung ating mga rules. And that is based on equity and justice. So we are not literally bound by the technical rules of procedures in an administrative case. For example na lang dyan is, meron tayong deadline to submit a paper, sabihin natin yung answer ng defendant. So meron, sabihin natin, example, 10 days. Ito ngayon, si defendant, nag-file ng kanyang answer on the 11th day. Pero, ang ground niya on the 11th day is that nagkasakit siya. Sabihin natin, nagkaroon siya ng COVID. Of course, pag nagkaroon ka ng COVID, naka-quarantine ka, wala kang mga resources or other materials para makapag-file ka ng iyong response, ay hindi naman natin dapat agad-agad na i-apply strictly yung law na 10 days lang dapat. We have also to consider the circumstances surrounding po ng ating mga case. So we are not strictly bound by the technical rules of procedures. Pwede po tayong maging lenient dyan. So second, administrative due process does not require at all times a trial type hearing. So ayan. As a quasi-judicial body po, hindi po required na magkaroon tayo ng trial type hearing. Meron pong ibang sanggunians na sufficient na magkaroon ng mga exchange of documents or papers. So as long as nasasagot nung kalaban or nung inireklamo yung reklamo laban sa kanya at nabasa naman iyon ng kabilang party at pwedeng sagutin naman din nung party na iyon, ay sufficient na din po iyon at hindi naman po tayo required ng magkaroon ng talagang totoong trial type na hearing. So third po natin dyan is that decisions may be reached on the basis of position papers and other documentary evidence only. So ito na nga po yung sinabi ko na hindi naman po natin kailangan ng trial type hearing, is that sufficient na po yung magkaroon ng mga position papers as long as nasagot po siya ng bawat parties, na-observe yung due process, and na-consider po yung mga documentary evidence na na-present. So sufficient na din po yun. Next slide po. So fourth, administrative decisions must state clearly and distinctively the facts and the law on which they are based. So ito po yung importante sa ating due process, na yung decision po natin ay dapat clear and concise doon sa mga facts na nakita sa proceedings. And yung ating mga issues involved, yung mga na-raise na issues, ay kailangang masagot with legal basis. So yun po yung ating fourth rule. So ating last rule is that the evidence presented before the tribunal or quasi-judicial body must have at least a modicum of admissibility for it to be given some probative value. So ito po yung sinasabi ko kanina na hindi basta-basta na i-accept na lang natin yung mga evidence na pinipresenta before us. We have to consider if it is admissible in evidence under our rules of court. Or meaning, yung witness, kailangang may knowledge, actual knowledge, hindi lang yung sabi-sabi sa kanya. May actual knowledge doon sa nangyari or doon sa ikinomplaint na reklamo. Or sa ating mga evidence, kailangan ito ay hindi photocopy lang. Kailangan ito ay original, authenticated, or verified. Unless masusunod na lang yung ating secondary evidence. Pero as much as possible, we have only to consider those evidence which are admissible in character. So yan po yung ating mga liberal applications ng ating rules. Next slide po. So ito, another question po is that yung kailangan po ba ng lawyer ang isang ng isang defendant sa ating administrative case? So ang sagot po dyan is, it is not mandatory. The right to counsel is not indispensable to due process unless required by the law or by constitution. So hindi po mandatory na magkaroon po ng lawyer yung ating defendant unless i-invoke niya po yung kanyang right to have a lawyer. So meaning, siya po yung maghahanap ng lawyer niya to defend his case. Pero in administrative cases, lawyers are not really required. So hindi naman po kasi siya ni-require din ng ating local government code. So sufficient na kahit siya lang yung mag-defend sa sarili niya. Pero of course, as on the part of the defendant, para naman ma-ensure ko rin na ako ay mapoprotektahan sa aking mga karapatan, is that I will ensure na lang or I will engage the services of a lawyer. However, of course, lawyers assistance may sometimes require a monetary value or a fee. So it will depend na lang po sa ating defendant kung mag-hire siya ng kanyang lawyer. So next slide po. So what are the three basic principles in administrative investigations initiated by a complaint? So ano ba yung mga burdens ni complainant sa pag-file ng kaso sa isang local elective official? First, the burden is on the part of the complainant to have his allegations as long as they are supported by substantial evidence. So kung ikaw yung nagreklamo, ikaw yung complainant, ikaw ang may burden to prove lahat ng iyong mga allegation. Hindi ipo-prove iyon nung defendant or nung kung sinong inireklamo mo. Yung complainant yung magpo-prove based sa mga evidences or evidence and witnesses na kanyang isasubmit sa local sanggunian. Another principle is that findings of fact made therein are to be respected as long as they are supported by substantial evidence. So kung meron na po tayong decisions and meron na po tayong na findings sa ating mga facts, yan po ay dapat i-respect ng both parties as long as it is supported by substantial evidence. Ito po yung substantial evidence, yung na-mention ko kanina, ito yung ating quantum of proof sa ating mga administrative case. So last principle po is that an administrative decision or findings can only be set aside on proof of grave abuse of discretion, fraud, or error of law. So as much yung decision po ng sanggunian kapag natapos na po yung ating mga hearing is that it is final and executory. Meaning, hindi na po ito madideclared invalid unless merong pong proof of grave abuse of discretion or merong fraud na nangyari doon sa pag-investigate po ng kaso or merong error of law or meaning na iba po yung pag-interpret nung batas over that particular case. So yan, dapat po nating tandaan ito para hindi po tayo magkamali sa ating mga proceedings sa mga administrative case po ng ating mga local sanggunian. So next slide po, ma'am. So reconciliation of the parties or desistance by the complainant. So ano po ba yung mangyayari kapag nagkasundo bigla yung ating complainant at yung defendant? So ang sagot po dyan ay yung reconciliation of the parties does not strip the court or the quasi-judicial body of its jurisdiction to hear the administrative case until its resolution. So yun, ibig sabihin po niyan ay tuloy-tuloy pa rin po yung pag-hear ng ating kaso until resolution or unless nagkaroon po ng majority decisions ang ating sanggunian to also dismiss the case on a valid ground na iyon nga po ay nagkasundo na po yung parties at they are no longer pushing through with the administrative case. However, that still depend on the will po ng ating mga local sanggunian. And the purpose of an administrative proceeding is to protect the public service based on the time-honored principle that a public office is a public trust. So yun po yung reason behind that kung bakit hindi agad-agad madidismiss yung case kapag nagkasundo yung ating mga complainant at defendant. So last slide po. Last slide na po pala ito. So in summary po ng ating mga na-discuss sa ating first part ay yung nature of quasi-judicial functions, the quasi-judicial powers, the requisites for exercise of judicial powers, the administrative due process, substantial evidence, and the liberal interpretation of our rules. So we have to take this in mind and para hindi po tayo magkagulo or mahirapan sa ating pag-exercise ng quasi-judicial function. So for my last slide, allow me to share a phrase from our Supreme Court, Ombudsman's versus de Sahagun. In disciplining public officers and employees, the object sought is not the punishment of the officer or employee, but the improvement of the public service and the preservation of the public's faith and confidence in our government. So yun po, maraming salamat po sa pakikinig. This is Attorney Erwin L. Palangka po. Thank you po. And for your questions, we will answer it po after several discussions po mamaya. Thank you po. God bless po.
Yan. Thank you very much, Attorney Erwin. Bigyan naman po natin ng masigabong virtual clap ang napakahusay po no, na, and very succinct na pag-discuss po ni Attorney Erwin ng local sanggunian as a quasi-judicial body. So yun nga po, no, ito po ay hindi bilang isang punishment, kundi ito po ay pagpapaunlad ng ating mga serbisyo para sa public. So para sa bayan po at the end of the day. So tama po si Attorney Erwin will be addressing all the questions after po nung ating 3 sessions. Para naman po may time pa tayo maitahi lahat ng ating 3 topics together at makapag-isip-isip po ano po yung ating mga katanungan. So again po, na virtual clap po or pagpuso kung gusto rin natin para kay Attorney Erwin para sa kanya pong discussion. Thank you very much, Attorney Erwin. So bago po tayo Opo, maraming salamat, sir. Ang susunod naman po nating session, kadugtong po nito, para po susugan yung ating unang topic na ito, ay dadako na po tayo sa ating second session. So ito naman po ay ang ating disciplinary actions for elective officials, given nga po yung ating unang discussion. Ito naman po ay i-discuss at ipipresent sa atin ng isa pang napakahusay na amin pong lawyer din dito sa DILG Mimaropa. Walang iba kundi ang aming Legal Committee Officer, si Attorney Raymond Alvin Mendoza. Magandang umaga po, Attorney Ram. Ayan po, Attorney Ram, you may unmute na po. Okay.
Nadidig na po ako.
Yes po, Attorney. Very, ano nila po. Opo. Medyo malayo lang po yung, parang audio po yata natin, Attorney.
Ito po, okay na.
Ayan, better po.
Kindly, Sir Marvin, kindly share my screen. Kaway lang po. Okay, good morning everyone. Raymond Mendoza po, kasama po ni Attorney Ervin Palangka to continue his earlier discussion. Kanina po, binigyan po niya tayo ng background as regards sa exercise of quasi-judicial functions, and madami din po siyang substantive portions na na-discuss regarding procedure. In the second module, we will be providing you with the grounds for discipline of local elected officials. Bakit po? Obviously, hindi naman po tayo pwedeng mag-file ng complaint indiscriminately against anyone, or in our case, any local elected officials. Mali naman po yun. Hindi po tayo pwedeng basta trip natin kasuhan, kakasuhan natin. Although in our work as, or even as appointed officials, we are prone to administrative cases, but we cannot just indiscriminately file without having a factual basis that is provided by law. And it should be backed by pieces of evidence. Ano po yung grounds? Unang-una po, as mentioned earlier, and most probably a lot of us has been reading these provisions in the code.
Hello po, Attorney Ram. Pasensya po, medyo malayo lang po talaga yung ating audio. Baka po pwede nating ilapit-lapit lang po ng very slight yung ating mic.
Eto, malapit na.
Ayan po, better po.
Number one, for the grounds, disloyalty to the Republic of the Philippines. Ano po yung last four words? This Republic of the Philippines. Hindi po siya disloyalty to the president, to the governor, to the mayor, or to the political party. It is disloyalty to the Republic of the Philippines. Ano po ito in its plain terms? Consists of abandonment or renunciation of one's loyalty to the government or advocating the overthrow of the government. Bakit po kaya siya kinonsider na grounds? May nakakaalam po kaya? It is considered as a ground for discipline of local elected officials, and not only local elected officials, but also for appointed officials, whether in the national government or in LGUs. Bakit po? Remember when we took our oath as public officials, ano po yung unang nababasa natin doon na very common but very important? And that is to swore to defend, uphold the Constitution and the laws. Kasama na din po doon yung loyalty natin sa Republic. Bakit po? Kasi yung pong saligang batas natin, doon po tayo kumukuha ng powers natin. Powers natin to govern, to exercise our function. So it would be contrary to our oath if we will be disloyal to the Republic. Mask ko. Sige. Sandali lang po. Papalitan niya tayo mask. Yan, nagpalit po ako ng face mask. Next slide, please. Yeah. Next, we have the culpable violation of the Constitution. When we say culpable, it is not to be understood as unintentional violation or accidental violation. What we are contemplating in this ground is the willful and intentional act or omission that is contrary to the Constitution. Bakit po ulit? Remember when we took our oath of office, ang atin pong sinusumpaan na ipagtanggol, sundin ay yung saligang batas. So again, it will be contrary to our function if ang ating gagawin ay labag dun sa saligang batas na nagbibigay sa atin ng kapangyarihan para gawin yung trabaho natin. Next slide, please. Dishonesty. Yeah. Pag sinabi nating dishonesty, it is the concealment or distortion of truth which shows lack of integrity or a disposition to defraud, cheat, or deceive. Pag sinabi po nating concealment, distortion, we are making false representations in an obvious attempt to defraud, cheat, or deceive, or to hide the truth. Yeah. Next slide, please. Dishonesty can also be considered serious or less serious if the following are present. The dishonest act causes serious damage and prejudice to the government, or there is an abuse of authority to commit the dishonest conduct. Next slide, please. Letter C, when the respondent is an accountable officer. Dito sa paragraph na ito, if there is a dishonest conduct that directly involves property, accountable forms, or money, this may also give rise to criminal liability for possible malversation. When the dishonest conduct exhibits moral depravity on the part of the respondent, when the respondent employed fraud and or falsification of official documents, and the commission of the dishonest conduct is related to his or her employment. Dito po sa letter E, possible din po na aside from administrative liability, ay pwede rin pong maging criminally liable for falsification of public documents. Next is when the dishonest conduct is being committed several times paulit-ulit. So, and other analogous circumstances. Next slide, please. Oppression or grave abuse of authority. Almost correlated po itong dalawang ground po na ito, no? When we say grave abuse of authority, it may include infliction of bodily harm, or injury, or just plain cruelty, severity in the exercise of authority. Next slide, please. Misconduct in office. Yeah. It is the transgression of some established and definite rule of action as a result of a public officer's unlawful behavior, recklessness, or gross negligence. It can be classified as simple or grave. in grave misconduct, there is that elements of corruption or a clear, deliberate intent to violate the law or in flagrant disregard of established rules. And it must be clearly manifested in the acts of the respondent. Next slide, please. Negligence, yan, kapabayaan. Pag sinabi nating negligence, we fail to exercise that amount or that degree of due diligence in performing our functions. It is also defined as the failure of an employee to give proper attention to a required task or to discharge a duty due to carelessness or indifference, yung wala tayong pakialam, kapabayaan, and as a result of our carelessness or negligence, it causes damage to the government or to a third person, especially to your constituents, di ba? Pag sinabi naman nating gross neglect of duty, it is the want or lacking of even the slightest care on our part in exercising our function. Like, for example, we have been in the service for a certain period, but despite that long period in the service, there might be an instance or there is an instance that we failed to exercise that due diligence required of us. Klaro po tayo doon? Next slide, please. Absences, kasama din pala. Yeah. Absent ka for more than 15 consecutive days nang hindi ka nagpa-file ng LOA. Pwede rin pala maging ground for disciplinary action. And travel abroad without due notice or without authority, unauthorized absence din pala. Next slide, please. Kanina, we've mentioned the grounds. Now, we have to determine the entity which has jurisdiction. Obviously, in our case, the Sangguniang Bayan. Next slide, please. For the procedure, madali lang naman po. We can take it liberally in its plain terms. Within 7 days after the complaint is filed, the Sanggunian shall send a notice to the respondent directing him to file his answer within 15 days from receipt of the notice. Now, ano po yung format kaya ng answer dito? That depends on the Sanggunian po. Mas maganda if it is prescribed in your internal rules of procedure. The answer may be in the form of a counter affidavit or a pleading such as those being filed in court. But preferably, it is better for you, the Sanggunian, to adopt the procedure of practice before your offices in case of when you will be handling administrative cases. As mentioned kanina by Attorney Ervin, we are not bound by technical rules of procedure. Let us say, sa dami ng ginagawa natin, nakapaglabas tayo ng notice to the respondent after 7 days. May possible violation po kaya tayo doon? That depends po. Kung reasonable naman po yung period natin na delay, and hindi naman po sabihin natin after 10 days na padala natin yung notice for justifiable reasons. Tandaan po natin, we are not bound by technical rules of procedure. So pwede din naman po yun. After receipt of the respondent of the notice, let's say he has undergone isolation without any resources on his part, or talagang madami lang pong ginagawa yung si respondent that he cannot submit his answer within 15 days from receipt. And ang ginawa po niya ay he informed the Sanggunian, maybe personally or in writing, that he is requesting for an additional period of 5 days or even 10 days within which to file his answer. Depende na po sa Sanggunian yon if they will find the reason for the delayed submission meritorious. But let us always remember, we are not bound by technical rules of procedure, not unless yung delay na ginagawa ng respondent or his failure to file within a reasonable period is for the purpose of deliberately delaying the proceedings. Malalaman nyo naman po yun in your own evaluation of the case. Then upon receipt of the answer or the counter affidavit, you will commence investigation within 10 days from receipt of the respondent's responsive pleading. Next slide, please. The venue. Malino, wala naman sigurong issue dito, very clear. It shall be done where the Sanggunian concerned is located. Bakit po kaya? Most likely, if a barangay official under your jurisdiction was impleaded as a respondent in an administrative case, malamang in the conduct of investigation, doon lang din naman sa area niyo yun. Kasi doon lang din naman ginawa yung act or omission that give rise to the administrative complaint. Diba? Practical reasons po yun. Next slide, please. Limitation in the conduct of administrative investigation. No investigation shall be held within 90 days immediately prior to any local election. No preventive suspension shall be imposed within the said period. So 90 days immediately prior to any local election, pwede naman po nating bilangin on our own yung period ay hindi po muna tayo pwedeng gumawa ng administrative investigation. Or if a preventive suspension has been imposed prior to the 90-day period, immediately preceding the local election, it shall be deemed automatically lifted upon the start of the said period. Now, what do you think is the reason for that limitation? Ano po sa tingin po natin? Okay, as mentioned by Attorney Erwin before, and also for practical reasons and factual, this exercise of disciplinary action or the administrative investigation may be used politically. Diba? Tingnan po natin yung instance wherein within 90 days immediately prior to any local election, it is a possibility that indiscriminate filing of cases can be filed dun sa concerned local official by the opposing side. Diba? Pwede po mangyari yun. And obviously, dito sa 90-day period na ito, karamihan po sa atin magpe-prepare na para tumakbo, di ba? Either for re-election or nagko-contemplate po tayong tumakbo a different position, di ba? So, the conduct of administrative investigation might hamper kung ano man yung goal natin for that election period. But for us, it can lead to an indiscriminate filing of cases na iniiwasan natin, di ba? Next slide, please. Preventive suspension, how is it imposed? After the issues are joined, when the evidence of guilt is strong, and given the gravity of the offense, there is a great probability that the continuance in office of the respondent could influence the witnesses or pose a threat to the integrity of the records and other evidence. How are the issues being joined? It's when it is upon the filing of the complaint and upon submission of the answer from the respondent, you'll probably make a determination on whether or not there might be liability on the part of the respondent. Now, question, even if the evidence of guilt is not strong, let's say there are several lawyers who are in the Sanggunian who are all well versed in the rules of procedure, specifically the rules on evidence, and upon evaluation of the complaint and submission of the answer, it is apparent that the evidence of guilt is not strong. Ano po kaya gagawin natin doon? Depende po uli sa inyo. You can use paragraph number 3 that given the gravity of the offense, there is a probability that the continuance in office of the respondent could or may influence the witnesses or pose a threat to the records and other pieces of evidence. Di ba? Diyan, tingnan po, ang guide lang po natin is that there might be a probability. Probability lang po even if the evidence of guilt is not strong. Remember, liberally construed po ang rules natin dito, not bound by technical rules of procedure, including procedure. Next slide, please. Next. Who imposes the preventive suspension? Kanina, it is the Sanggunian who determines if there is a necessity for the respondent to be placed under preventive suspension. Upon determining that necessity, it is the mayor who imposes upon the recommendation by the Sanggunian. Now, tanong po natin, what if the mayor, who is a former trial lawyer, very versed with the rules of procedure, and upon his receipt of the recommendation from the Sanggunian, ay nakita niya, based on his sound evaluation, ay wala namang ground for the imposition of preventive suspension. Ano pong gagawin niya doon? Wala po siya magagawa doon kasi the determination on whether or not preventive suspension may be imposed is lodged with the Sanggunian. Bali ministerial po ito on the part of the LCE. Period of preventive suspension, single preventive shall not extend beyond 60 days. In the event that there are several administrative cases filed, he cannot be preventively suspended for more than 90 days. So kahit madami po pala kayong final na admin case, within the same year on same grounds, it shall not extend beyond 90 days. Mamaya makikita po natin why a single preventive suspension shall not extend beyond 60 days or for several administrative cases filed within the same year, not more than 90 days. Next slide, please. Upon the expiration of the preventive suspension, the suspended elective official shall be deemed reinstated in office. So automatic po itong reinstatement na ito, wala na po siyang ibang gagawin. Basta tama po sa bilang, natapos ngayong petsa yung kanyang preventive suspension, deemed reinstated po siya. Then the period within which to terminate the administrative investigation is 120 days from the time that the respondent was formally notified of the case against him. When is that formal notification? That is the time when you have sent a notice to the respondent to submit his responsive pleading. Eh what if, dahil sa lahat tayo busy tayo lahat sa trabaho natin sa LGU, lalo na ngayon, we are in a state of public health emergency, eh medyo lumampas tayo ng konti sa 120 days. Pwede naman po yun. Huwag lang masyadong substantial yung delay. That it might give rise to an instance wherein it is the Sanggunian who will be subjected to a disciplinary action for negligence. Kasi let's say 120 days ang sinasabi dito that we should terminate the conduct of investigation. Ay inabot tayo ng 1 taon, hindi pa tapos. Ay malamang substantive yung delay na yun, di ba? And remember, we are not bound by technical rules of procedure. Hangga't maaari, rules are liberally construed for the purpose of immediately administering justice and to determine whether or not there is liability, di ba? What if the delay of the proceedings was due to the respondent? Ayan, second paragraph po. If the delay in the proceedings of the case is due to default, negligence, request, or other caprices other than the appeal duly filed, the duration of such delay shall not be counted in computing the time of termination of the case, especially if for obvious, when it is apparent or for obvious reasons, the respondent is the one who is causing the unjustified delay in the proceedings. Siguro, file ng motion for extension to file his responsive pleading. Siguro naman, after 2 motions, he will be able to capably prepare his answer to the complaint with or without the assistance of a lawyer. Next slide, please. So related din po ito dun sa rules in the imposition of preventive suspension. It is immaterial that no evidence has been adduced to prove that the official may influence possible witnesses or may tamper with official or public records. It is sufficient that there is a probability. Now, who determines that probability? It is the Sanggunian. However, let's say if there is not even the slightest probability that such fact exists, wherein there might be influencing of witnesses or tampering of public records. But still, the Sanggunian imposed preventive suspension. That may constitute grave abuse of authority on the part of the Sanggunian. The imposition of preventive suspension is not meant, we should remember that it is not meant to harass the respondent. Next slide, please. As mentioned before, the authority of the LCE to impose preventive suspension is purely ministerial, since the disciplinary authority lies within the Sanggunian. So it is the Sanggunian who determines if there are sufficient cause to have the respondent preventively suspended and not the LCE. Remember, it is purely ministerial on the part of the LCE. Next slide, please. Salary during preventive suspension. Wala siyang susweldohin. But upon reinstatement, he shall be paid in full, including all emoluments accruing during such suspension. Madali lang naman pong intindihin ito. Next slide, please. What are the rights of the respondent in administrative case filed before the Sanggunian? As mentioned by Attorney Ervin kanina, we have to observe due process. Ano po siya? The opportunity to be informed of the charge against a person, and the opportunity to be heard through himself or by counsel. Kaya in the local government code, that constitutional provision was reflected. Respondent shall be accorded full opportunity to appear and defend himself in person, or if he can afford to, or by counsel, to confront and cross-examine the witnesses against him, and to require the attendance of witnesses and the production of documentary process of subpoena and subpoena ducis tecum. But can the Sanggunian dispense with the, or even upon motion of the respondent, can we dispense with the requirement to confront and cross-examine witnesses if, based on the complaint and the answer and all supporting documents or pieces of evidence, the Sanggunian can already make a decision based on substantial evidence? Pwede din naman po yun. Diba? Gaya po nabanggit din kanina, this is a formal or trial type hearing is not required in administrative cases. What is important is that there must be notice and an opportunity to be heard. Now, let's say, despite due notice to the respondent, he deliberately failed to file the responsive pleading despite due notice. Ano po magiging implication nun? He or she is waiving his right to defend himself. And later on, if ever that he or she will have an unfavorable decision, he cannot claim that he was not notified or he was not given an opportunity. Kasi yung pagbibigay ng notice to the respondent for him to file pleading, papers na nga lang po yun, hindi na po siya a-appear, that is considered as sufficient notice. We have already complied with the due process requirement. Next slide, please. Form and notice of the decision. First, investigation of the case shall be terminated within 90 days from the start thereof. And within 30 days after the end of the investigation, the OP, Sanggunian concerned, shall render a decision in writing. In writing yan. Hindi pwedeng pinatawag nyo yung dalawang partido at doon nyo na lang sinabi kung ano yung resolution ninyo, yung conclusion nyo doon sa administrative complaint. It must be in writing, stating clearly the facts, reasons for such decision, and the law that applies to the set of facts in support of the decision. Kasi hindi naman pwedeng may facts nga, reasonable naman. Pero wala naman applicable na batas doon sa decision. Hindi pwede yun, di ba? For obvious reasons. And the copies of the said decision shall be immediately furnished the respondent and all interested parties. So let's say today, the Sanggunian unanimously concluded the investigation of the case, and the day after a decision was made, again unanimously adopted by Sanggunian. How do we notify the respondent or the complainant? Paano kaya? Madali lang naman po, depende ho sa inyo. It is either personally through your process servers or by mail, depende po sa inyo. Pero kung malapit lang naman po, especially during election period, nakakapunta naman tayo sa malalayong barangay, baka pwede na sa process server yan, di ba? Next slide, please. Duration of the penalty of suspension. shall not exceed an expired term of the respondent or a period of 6 months for every administrative offense. And nor shall said penalty be a bar to the candidacy of the respondent so suspended, as long as he meets the qualification required for the office. The penalty of removal from office as a result of administrative investigation shall be considered a bar to the candidacy of the respondent for any elective position. Balikan ko lang po ulit yung preventive suspension kanina, may nakalimutan po kasi ako. The rules provide that single preventive suspension shall not exceed 60 days, and for several cases filed, it shall not exceed 90 days. Bakit po kaya kinakailangan natin to have a maximum period within which a respondent may be placed under preventive suspension? And that is 60 days. Bakit po kaya? Ang dahilan po nun, if the preventive suspension shall exceed shall exceed beyond the period provided by law, it is as if that we are indirectly penalizing the respondent without the case having been concluded. So, ilalabas nun, suspended siya ng matagal, while pending yung kaso, baka mas maganda pa nun ay bilisan na lang yung investigation at mag-impose na tayo ng penalty instead of the respondent having been placed in preventive suspension, which is indirectly penalizing him. Hindi po pwede yun kasi una, nababiolate po yung due process requirement, and next, it is violative of the Constitution, and that is the right of the respondent or accused to a speedy disposition of cases filed in any judicial or quasi-judicial bodies. Okay po, klaro po tayo doon. Dito naman po sa second paragraph, the penalty of removal from office. Clear naman po sa atin that it is only the courts was the authority or was the power to remove a local elective official in office. Wala po sa Sanggunian yan. Wala rin po sa Office of the President yan. Paano po ito? It presupposes that a criminal case was first filed in court, most likely for an offense involving moral turpitude, and the accused respondent was found guilty by the court. Only then that the administrative proceedings can be instituted to the respondent for the purpose of removing him by virtue of that court decision. Kasi in most cases involving moral turpitude, conviction of the accused most likely carries with it the penalty of absolute perpetual disqualification to hold public office. Yun po yung reason doon. Next slide, please. Of course, even if in case of unfavorable decision on the part of the complainant or the respondent, we still have the remedy, and that is either file an appeal to the higher Sanggunian or first file a motion for reconsideration before the Sanggunian that rendered the decision. Next slide, please. Execution pending appeal. An appeal shall not prevent a decision from becoming final or executory. The respondent shall be considered as having been placed under preventive suspension during the pendency of an appeal. And in the event that he wins such appeal and results in an exoneration, he shall be paid his salary and such other emoluments during the pendency of the appeal. So, even if the losing party to the case decides to contest the adverse decision, and thereafter he filed an appeal before a higher body, that appeal shall not prevent the decision from becoming final or executory. So there may be an instances wherein, despite the pendency of such appeal, the decision was already executed, placing the respondent under preventive suspension. Ang mangyayari po nun, in the event that the respondent shall be exonerated, that period of suspension as a penalty is considered as the respondent is considered preventively suspended, in which he shall be paid all of his salaries in full and such other benefits during the pendency. Sections. Next slide, please. MR, madali lang ito. We file a motion for reconsideration before the same body that rendered the decision. We do not file an MR to a higher body. But nevertheless, this will not stay the execution of the penalty. And for the Sanggunian, in disciplinary cases, it is immediately executory even pending appeal. But the reviewing authority, meaning the higher office, may issue a stay order pursuant to its review authority. So that depends on the appellate body in its sound discretion to determine if there is a necessity for the issuance of a stay order. Absence of such stay order or whatever, the decision is immediately executory. Next slide, please. May the Sanggunian suspend a secretary or appointed barangay official? Obviously, no. That power belongs to the CSC or to the LCE. As head of agency, having the authority to impose disciplinary actions. For the procedure, we can always refer to the rules on administrative cases in the civil service on the part of the LCE in the event that he decides to exercise disciplinary action over his subordinates. Next slide, please. Yan. Nabanggit natin kanina, kay na local Sanggunian, remove ang elective official of LGU. No, such power is exclusively vested in the courts. Next slide, please. May the Sanggunian hear a case when the respondent already resigned? No. Mentioned during the first module, the Sanggunian must have first a jurisdiction over the person of the respondent. And the Sanggunian loses jurisdiction over the person of the respondent if the respondent is no longer in service. One of the reasons is official relations have been terminated, and secondly, wala na ho kayong bibigyan ng penalty, di ba? I think this is the end of my presentation regarding the procedure in the conduct of administrative investigation. Lagi lang po natin tatandaan, you are not bound by technical rules of procedure. The goal in conferring upon the Sanggunian the power to exercise disciplinary action over subordinate local officials, it is because that administrative bodies or quasi-judicial bodies are more knowledgeable in instances or in cases that they have jurisdiction. And of course, for speedy disposition of cases, to prevent the courts from being docket congested with several cases, our guiding principle in our exercise of quasi-judicial functions is that to attain due process and to the speedy administration of justice. This does not only include determination of liability on the part of the respondent, but also to prevent him to be placed in an compromising situation wherein a case was filed against him, but it is apparent that such complaint is just meant to politically harass that specific local official. That I think this is my last slide. That will be all, everyone. Prior to the end of my presentation, I would like to thank our regional director, assistant regional director, the members of the group, their division chief, Ma'am Tess, for lending us their staff for us in order to successfully conduct this activity. I hope we have learned a bit or we have been refreshed regarding our non-legislative function, and that is the power to impose disciplinary sanction over erring local officials. That will be all, everyone. Thank you.
Okay, thank you very much, Attorney Ram. Bigyan naman po natin ulit ng masigabong virtual clap ang atin pong butihing attorney. And dahil nga po, no, napakagaling po ng pag-discuss ni Attorney Ram, he was already able to connect yung atin pong session 2 and session 3. So, as he discussed the disciplinary actions for our elective officials, napasadahan niya na rin po yung administrative hearing proper at yung proseso po nun para nga po sa ating mga cases, administrative cases. So, alam ko po na marami po tayong mga katanungan and clarifications at may mga ilan na po tayong na-note. Don't worry po, ninonote po namin yung ating mga na-chat sa ating chat box. I will be having a 10-minute health break po muna before po tayo sumabak sa ating open forum. So for everyone, you may already chat your questions po sa ating chat box or later po sa ating open forum proper, you may raise your hand para po ma-acknowledge po namin kayo if you want to verbally share a question or an experience or something po no, na clarification regarding your practices po at the grassroots level. So thank you very much po. Hopefully we'll have a lively and active discussion po after 10 minutes. So you may get your coffee first to get energized. So maraming salamat po. See you in 10 minutes. So that's at 10:44 a.m. Hi everyone! So welcome back to our session. So before we proceed to our open forum session, I believe, Attorney Ram, meron po kayong huling habilin or huling i-discuss po for our participants.
Again, good morning po. Nakalimutan ko po, mayroon pa po pala akong 2 slides, kaya lang simple lang naman po yung topics doon, pero it's better that we will be able to share that with you. Or banggitin ko na, okay, ito na po. Naka-share screen na po pala. Is the signature of the LCE required for the decision of the Sanggunian to be implemented? Hindi na po kailangan. However, it is the LCE or the mayor is the one tasked to implement. I cannot refuse he cannot sit down or refuse to implement such decision kasi function po niya yun. And non-implementation thereof, he can be charged with abuse of authority or dereliction of duty or even negligence. Abuse of authority because he has no authority over the conduct of investigation or evaluation done by the Sanggunian in the exercise of their quasi-judicial function. Purely ministerial na lang po ang function na dito. Then, next slide. What if instead of implementing, the mayor chooses to veto the decision of the Sanggunian for obvious reasons? Hindi po siya pwede. Kasi yung veto, it pertains to the legislative conduct of the Sanggunian. But in our case, hindi po ito exercise of legislative function but quasi-judicial function. Kaya even if the LCE does not agree with the decision of the Sanggunian, no matter how unpopular it is, or if based on his personal evaluation that the decision done by the Sanggunian is not in accordance with law or facts or pieces of evidence, wala din po siya magagawa dito. He cannot veto such, but the remedy is to file an appeal or an MR. Yun lang po. Thank you.
Okay, thank you very much, Attorney Ram, for those very important details pa rin po na malaman ng ating participants. So now, we'll be proceeding sa atin pong open forum proper. So, meron na po tayong simple mechanics here. So, aside po dun sa mga na-collect namin na questions sa atin pong YouTube live streaming, sa atin pong Zoom chat box, and some were personally sent to us po, will also be, ayan, sige, ako na lang po mag-share, sa atin pong secretariat. Okay. Ayan. So, we'll just be utilizing po yung raise hand feature ng ating Zoom. And right now po kasi naka-uncheck po, no, yung participants can unmute themselves. So we'll be allowing you to unmute yourselves po if you raise your hand so that we can acknowledge you po and you can verbally share. But for the first ilang discussions po, we'll be addressing po muna yung mga nakala po namin from the chat box. So Attorney Ram and Attorney Irvin, ready na po ba tayo para sa ating open forum session?
Hello ma'am, ready na po. Okay na po.
Ayan. Game ka na ba po yun? Okay, sige po. For our first question po, ayan, we'll be acknowledging po yung ating participants who raised their hand po, no? So for our first question lang po from Anonymous, so I guess ano po sila, no? Nahiya sila magpakilala. Some clarifications lang po. Yung quasi-judicial functions po ba ng Sanggunian ay for admin cases only ng LGU officials, hindi po kasama ang criminal cases. And related to that, yung LGU officials lang po ba ang sakop nito? Paano po yung ibang LGU employees like mga plantilla, COS or job order na hindi necessarily officials po? Ayun, anyone can answer po?
Ako na lang po muna sa sagot dito, ma'am. Usually, ma'am, so na-mention ko kanina, ay depende po ito doon sa jurisdiction na nakalagay po sa ating local government code. So, ang nakalagay po sa ating local government code, particularly section 60 to 61 po, is that yung quasi-judicial functions po ng ating sanggunian is mainly for administrative cases against elective officials lang po. So, hindi po dito kasama ang mga criminal cases or are committed by our elective officials, because criminal cases are filed with the Office of the Prosecutor's Office, at hindi po siya granted ng ating local government code na mag-hear ng criminal cases. So doon lang po tayo sa administrative aspect ng case based po sa ating local government code. So yung criminal aspect po ay nasa prosecutorial side na po yan ng ating government. So sa follow-up question, so kung LGU officials lang po ba ang sakop nito, ang nakalagay po sa ating local government code is that elective officials, hindi lang po LGU officials. Elective officials, meaning ito po yung mga officials na binoto natin sa election ng ating mga officials. So hindi po kasama dito yung mga permanent employees ng ating LGUs, kundi yung mga elective officials lang po. So hindi rin po kasama dito yung mga katulad po ng nakasabi dito is yung mga plantilla positions, COS or job orders, kasi sa administrative cases against those mentioned employees, sila po ay pwedeng mag-fall sa ating Civil Service Commission, or pwede rin po silang mag-fall sa Office of the Ombudsman. Pero sa ating pong mga local sanggunian ay hindi po sila under ng jurisdiction nila, kundi yung mga local elective officials na po. Yun po, ma'am.
Okay po, thank you po, Attorney Irvin, very clear po. Attorney Ram, may idadagdag po ba kayo, or very well put na po ba ni Attorney Irvin?
Extensive na yung discussion, ma'am, ni Attorney Irvin.
Okay po, copy po. Ayun, hopefully po sa kay Anonymous po, ayun, very clear po na for elected LGU officials po, applicable itong ating discussion. And yun nga po, kaya nga po may Quasi, doon po sa Quasi Judicial Functions, because this is specifically for admin cases only. So thank you very much po. We'll move on to our next. Sige po, go ahead po, Attorney Ram.
Yung binabanggit po natin dito na for administrative cases lang, pag binasa naman po natin yung provision sa LGC, nakalagay malinaw doon na po kagad, malinaw na it pertains to administrative cases.
Copy po. Okay pa, thank you rin. So very emphasize po na admin cases lang po ang ating scope. So for our next question po, pwede po ba patawan ng persona non grata yung bona fide resident ng same munisipyo or barangay? From Anonymous po ulit. Ayun. Attorney Irvin, Attorney Ram.
Sige po, Sir Irvin, at sa akin muna to, no?
Sige sir, kayo po muna.
Elaborate na lang pag kulang pa. Ulitin ko yung question, pwede ba patawan ng persona non grata yung bona fide resident ng pwede po ba akong mag-clarification dito? Bakit po natin papatawan ng persona non grata? Next, yung pong persona non grata, comment ko, hindi naman po siya punishable ng kahit anong batas natin. Ang basic po dito na no matter how undesirable po yung isang tao, yung resident na naninirahan sa ating locality, kahit nga po, kahit nga po tawag natin doon, mga kapatid natin sa kabila, very undesirable. Hindi naman natin yan pwedeng persahin na umalis dyan, even magpasa tayo ng ordinansa o resolution declaring them as persona non grata. Why? Violation kagad ng constitutional provision natin yun yung liberty of abode and to travel. Cannot be impeded by mere declaration or resolution. We need a court order po para doon. And lastly, hindi naman yung pagpataw po ng persona non grata, hindi naman po yan exercise of quasi judicial. Pwedeng patawan but wala namang implication kasi nga it is against the Constitution. Kahit ano pang declaration gawin nyo dyan is contrary to the Constitution, wala pong force and effect yun.
Okay pa, thank you po, Attorney Ram. So very grave po ito para maisip po na papatawan bilang persona non grata yung isang ating citizen. And nga po, hindi siya parte ng ating quasi-judicial functions. Attorney Irvin, may additional remarks po ba tayo?
Agree din po ako kay Attorney Ram na Yun nga po, hindi po ito part ng quasi-judicial functions ng ating mga sanggunian na mag-declare ng persona non grata sa isang bona fide resident. So, as much as possible, we have to respect one's right to liberty and to abode or to transportation. So, yun lang naman po. Thank you.
Ayan. Thank you po very much, attorney. So yun po, very clear po, this is not part of the quasi-judicial functions of the Sanggunian. Ayan. Next question na po tayo from Anonymous po ulit. Nakakarami na sila. What will happen if there are two admin case against an elective official, one with the Sanggunian and one with the Office of the Ombudsman? So, yun po, Attorney Irvin, Attorney Ram.
Ako na po sasagot dyan, ma'am. Dito po, kasi ang local sanggunian at ang Office of the Ombudsman, meron po silang concurrent jurisdiction over administrative case sa ating mga local elective officials. So pwede pong mag-file ng admin case sa sanggunian at pwede rin pong mag-file ng case sa Office of the Ombudsman. Pero ang tanong po dito, paano po pag dalawa yung naisampa? Sabihin natin, meron na kaagad na file sa sanggunian at meron ding sa Ombudsman. So ang sagot po natin dyan is that susundin po natin yung doctrine of primary jurisdiction. Ibig sabihin po ng doctrine of primary jurisdiction is that kung kanino po unang na-file yung administrative case, siya po yung magkakaroon ng jurisdiction from the beginning and until the rendition of the decision over that administrative case. So paano po natin ma-determine kung sino yung naunang nag-file doon sa sanggunian or sa ombudsman? So makikita po natin yan doon sa stamp received na i-file na complaint doon sa respective tribunals. If ever, kung nakita po natin na naunang na-receive ng ating mga local sanggunian yung complaint, ay tayo po ang may jurisdiction over that at hindi na po yung Office of the Ombudsman. Ganun din po if ever na naunang maka-receive yung Office of the Ombudsman ng complaint, sila na po yung magkakaroon ng jurisdiction over that particular admin case. So madidetermine po natin yan doon sa stamp received sa complaint at nakalagay din po kasi dyan yung particular date and time kung anong oras po na-receive yung complaint. So kung same day, maglalaban po yan doon sa oras na natanggap yung complaint. So yun lang po.
Okay. Very clear po. Thank you po. So yun po nang ipaprocess po at the Sanggunian and then the Ombudsman level. So kung ano po yung nauna na nasa MOV po natin, yung sa stamp receive, doon po una ipaprocess. So thank you po, Attorney Irvin. May additional remarks po ba tayo, Attorney Ram?
Further comment po, ma'am. Very extensive na po yun.
Okay po, thank you very much po. So moving on po tayo sa ating next question. So ito po from Anonymous po ulit. Na mag-vary po ba ang disciplinary action sa naggawang grounds for disciplinary actions? Who should decide what kind of disciplinary action should be done? Parang ang tanong po yata dito is may level of disciplinary actions, depende po dun sa actual complaint or depende po dun sa actual hatol?
Yeah, akin naman po ito kasi kanina si Attorney Ervin. Padagdag na lang bro kung kulang yung akin .
Okay, sir.
Simulan natin dun sa follow-up na lang muna. And I'll try to correlate it to the first inquiry. Who should decide what kind of disciplinary action should be? Magsisimula po ito, depende po dun sa complaint that will be filed by the person authorized to file a complaint. Bakit po ganun? Hindi naman po makakapag action ng sanggunian or the sanggunian cannot exercise its quasi-judicial function kung wala pong complaint that is being instituted. So, ang unang titingnan po dyan ng sanggunian ay yung allegations dun sa complaint na na-file. And pwede naman pong nangyayari na the designation of the offense being imputed sa complainant, let's say, ang nilagay po ng complainant doon ay for grave misconduct. But upon review, upon evaluation of the sanggunian of the allegations dun sa complaint and the attached pieces of evidence or documents, it appears that hindi naman po misconduct yung lumalabas. Pwedeng lumalabas pala sa complaint ay negligence. Diba? So, the decision on what kind of disciplinary action should be done depends on the factual allegations in the complaint. Yun po yun. Magva-vary po ba yung disciplinary action sa nagawang grounds? Siguro, na-address na ito dun sa follow-up. Yung sinasabi natin na magva-vary, the designation of the offense in the initiatory pleading sa complaint, maaaring iba yung magiging allegations. So, ang susundan po natin ay yung allegation sa complaint.
Okay po. Very clear po on that, Attorney Ram. Attorney Irvin, may follow-up po ba tayo?
Ayun lang po, ma'am. Agree po ako doon kay Attorney Ram na kung nagbavari po yung mga allegations sa complaint, yung magiging basis po natin doon is kung ano yung ultimate na allegations na nakasaad doon sa pleading, ay yun po yung ating magiging particular ground for the administrative case.
Ang ginamit namin basis dyan, ma'am, ni Attorney Irvin, yung napag-aralan namin sa criminal procedure. Let's say a complaint for PI was filed against, let's say, sa isang tao for rape. Upon evaluation by the prosecutor of the complaint, wala namang rape. But there's that offense which is necessarily included dun sa complaint. Like, wala namang pagagasang nangyari, but may kamanyakan nangyari. The acts of lasciviousness yun. Necessarily included din dun sa crime ng rape. Kaya pwedeng the allegations, the designation or charge might state rape, but upon evaluation ng complaint, acts of lasciviousness lang, which is also necessarily included dun sa unang reklamo. Okay, at the same time, lari ka pa din. Ganun lang po yun. Ganun lang po.
Additional lang po, if ever po na ganun nung mangyari, meron talagang variation doon sa ating allegations sa complaint, pwede po siyang mag-fall din ng violation of due process or violation po doon sa notice on the right to know what are the allegations against doon sa respondent natin. So if ever talagang malayong-malayo yung allegations doon sa complaint at doon sa kung ano yung ground na state, is that magkakaroon ng violations ng due process on the part of the respondent. So yun lang po.
Thank you very much po, Attorney. So very clear po, no? Yes po, may variations po and depende po yun sa process po natin nung ating initial complaint. So moving on po tayo sa ating next question. Ayan, anonymous po. After po nito, may mga pangalan na po yung ating question. So, what action will the Sanggunian take if the complaint filed before them is outside or beyond the jurisdiction of the Sanggunian?
Attorney Irvin yan.
So, ito po, sa jurisdiction na naman po tayo. Sinabi po natin kanina na kapag outside po ng jurisdiction or walang jurisdiction po yung Sanggunian to hear that particular admin case, ang mangyayari po dyan is that pwede pong mag-usap ang buong sanggunian and ask the majority of the members if you will take or not the administrative case filed. So meaning you can dismiss it outright. However, you have to put it into writing and stating the grounds thereof for dismissing the case filed with the Sanggunian for being beyond your jurisdiction. So yun po yung ating sagot dyan sa question na yan.
Okay, thank you very much po, Attorney Irvin. Okay. So, ayun po, moving on na po tayo dun sa, ito, yung mga previous questions naman po was, ano po kasi personally message to us. So, moving on naman po sa tanong po ni SB member Councilor Ogalinola, is it proper if the Sanggunian call a committee meeting right after the complaint received to discuss and determine whether found with probable cause before sending a letter to the respondent for his or her verified answers?
Sige po, magbigay po ako ng initial comment dito, and if insufficient, Attorney Irvin will top me up. Let me read again the question. Is it proper if the Sanggunian call a committee meeting right after they receive the complaint to discuss and determine whether found with probable cause before notifying the respondent to submit his answer? In relation po ito dun sa preceding question, which was answered by Attorney Irvin, the Sanggunian, upon receipt the complaint, may in their own discretion make an initial assessment or review of the allegations thereof. The function lodge exclusively naman sa kanila ito eh. And siyempre, let's say if upon extensive review of the Sanggunian, they have determined that the complaint is obviously baseless or it is not supported by evidence, or the complaint filed is not among the grounds for provided by the local government code or such other laws. As mentioned ni Attorney Irvin, the Sanggunian may dismiss it outright, pero hindi pwedeng pag-usapan nyo lang doon na, sige, dismiss natin. Hindi pwedeng gano'n. Like Attorney Irvin mentioned, the dismissal must be in the form of a decision. It must be in writing, supported by the facts, pieces of evidence, and the law that is applied to in support of that said facts. Ganun po yun.
Thank you very much po, Attorney.
Yun po, but Attorney Irvin might have something to add on. Sige po.
Opo, agree din naman po ako doon sa sagot ni Attorney Ram. Dito lang po is yung sa whether found with probable cause yung case. Ano po kasi, ang comment ko lang dito is that yung probable cause is a legal term po siya na ginagamit sa ating criminal law. So we are dito sa ating quasi-judicial functions, we are referring to administrative cases and not criminal cases. Kasi ang probable cause po, ito ay isang procedure to determine whether or not there is a probability that a crime has been committed. Pero dito po sa atin sa admin case, ang comment ko lang po is that ang pwede po nating pag-usapan dito sa committee hearing, if your rules of procedure permits that you can conduct a committee hearing, is that pwede naman po kayong mag-determine. However, yung i-determine niyo is not the probable cause itself because it is a criminal law term. But pwede nyo pong i-determine na lang yung sufficiency of the complaint or the allegations. If you think that the complaints or the allegations in the complaint are well sufficient or sufficient enough in order to prosper an administrative case, so yun po yung pwede nating i-consider. So yung probable cause po is medyo technical po kasi siya. So pwede po nating i-determine na lang is kung sufficient po ba yung complaint. If not sufficient, we can dismiss it. However, we have to state our grounds. Or if it is sufficient, saka na po tayo mag-issue ng summons para sa ating respondent. Yan po, thank you.
Okay, thank you very much po, attorneys. Tanong lang po natin si Councilor Ogalinola. Pwede po kayo mag-chat or thumbs up react if sagot po ba yung ating question, sir? Ayan, pwede po tayo, inalaw na po namin mag-unmute if you have further clarifications po, pero parang hindi po yata naka-connect po yung kanilang audio. So you may, ano lang po sir, chat po if mayroon po tayong follow-up questions. Thank you po, Councilor. So from our next and I think last question po yata, dun sa ating sa first batch of questions, this is from our personnel. So from Sir Wally Ferreira of the LGB Maropa, can you enlighten me on the sample of cases involving moral turpitude? So Attorney Ram?
Ay, galing ito sa personnel natin, Wally Ferreira. Di ba naka-warranty nito? Tanong niya ay
Productive po yung quarantine niya.
cases involving moral turpitude. Definitely, agree si Attorney Irvin din sa akin dito. Though walang clear-cut definition yung crimes involving moral turpitude, masyadong broad siya in its description, even in Supreme Court decisions. But pag ang common dito ay yung the conduct, the act or omission would show moral depravity on the part of the person committing such crime. And then nag-lay down din ng example dito ang SC, what are the crimes involving moral turpitude. Kagaya po ito ng obviously murder, homicide, rape, and those other offenses that are inherently wrong. Yung hindi mo na po kailangan ng batas para lang masabi na siya ay mali. Kasi meron po tayong principle sa criminal law na there are offenses or crimes that are mala in se and the others are malum prohibitum. Crimes or felonies provided under the revised penal code are considered mala in se. So, ibig sabihin nun, maling-mali na talaga siya from the start. While when we say malum prohibitum, the act or omission may not be inherently wrong, but the Congress or the legislature deem it proper to make that act or omission punishable. Like yung Dangerous Drugs Act natin. Dangerous Drugs Act, hindi naman siya punishable under revised penal code kasi hindi naman siya inherently na mali. But the legislature decided it to be punishable. Bakit? To address that menace in the society of illegal drugs. Bouncing checks law, hindi naman siya yung pag-i-issue ng cheque na nadi-dishonored. Hindi naman siya inherently na mali. But in order to penalize the practice of deceiving others and the issuing of checks that will be later on dishonored, a special law was enacted by the legislature, specifically addressed to address the violations of issuing dishonored checks. Parang ganun po. Pag sinabi nating moral turpitude, yung talagang maling-mali po talaga siya. Alam naman natin siguro kung ano yung talagang mali.
Okay, thank you very much po, Attorney Ram. Sir Wally, did that satisfy your question? Pwede po tayo mag-chat or thumbs up react? Ayan, parang nawala na po yata si...
Ma'am Charles, add lang po ako dito sa question ni Sir Wally.
Sige po, go ahead po, Attorney Irvin.
Based lang po kasi dito sa definition ng Supreme Court, ang moral turpitude is defined as everything which is done contrary to justice, modesty, or good morals. It is an act of baseness, vileness in the private and social duties which a man owes his fellow men or to society in general. So meaning, ang moral turpitude po ay depende upon the circumstances po nung nangyari sa isang case. Hindi po sinabi na basta't mali siya ay moral turpitude kaagad. So depende po siya sa circumstances surrounding a particular case before natin siya masasabing moral turpitude. So yun lang po yung additional insight ko po.
Thank you very much po, Attorney Irvin.
Mm-hmm.
Ayun,
may additional po.
Yes po, Attorney.
Mayroon pong additional sa ating chat box, ma.
From LG, ito po ba yung from LGU Coron?
Yes, ma'am. Ayan ako.
Agad dyan si Attorney Irving.
Oo nga po. Follow up for LGU Coron po, follow up po ba ito sa current question po or doon po sa ating na-chat po na question? Sige po, pwede po natin sila balikan later. Nag-thumbs up na rin po kanina si atin pong si Councilor Ogalinola po para po sa kanyang question. So, that ends po yung ating first batch ng mga natanggap po natin sa atin pong Zoom chat box. So, ngayon naman po, bibigyan po natin ng pagkakataon yung mga naka-raise hand naman po no, to verbally share or ask their question po. So, unahin po natin dyan si SB Manrique po from Buwak, Marinduque. Sir, you may unmute na po your microphone.
Thank you po, thank you. And good morning po ulit sa atin pong mga hosts, sa mga nagko-conduct po, sa mga nag-lecture, and sa mga fellow participants po natin. At dito po kasi sa amin ay we're pretty strict po sa rule on verification. So kapag complaint po should be verified, the answer should be verified. Pag hindi po na-meet yun, binabalik naman po namin, and then we ask whether it's the complainant or the defendant to submit a verified version. Pero po kapag po kasi nandito na sa hearing proper, ay kinakailangan po talaga sa amin is ang practice po ay under oath po ang mga sinasabi ng mga ano po ay mga complainant or the witness or the defendant. So sino po kaya ang officer that is authorized to administer oath sa mga ganong proceedings? In our case po dito sa aming Sangguniang Bayan, ang nag-administer po ng oath for some time now is it's either the secretary to the Sangguniang Bayan or it's me, yours truly, as the chairperson of the Blue Ribbon Committee. So, authorized po bang pwede po bang ganun ang procedure, or is there any other official po within us na pwede pong siyang mag-administer ng oath?
Hello po, Attorney Irvin, Attorney
Hello
Lam.
po. Hello po. Usually, sir, as much as possible, since a local sanggunian is considered a quasi-judicial body, ang ating pong mga sangguniang members are considered semi judge po doon sa ating proceeding. So, kung sino po yung presiding officer ng ating quasi-judicial body, ng ating administrative hearing body, ay siya po yung necessary na mag-administer ng oath ng mga parties involved po doon sa administrative case. Kasi kung titingnan po natin, if yung katulad po sa sinabi nyo kanina is yung secretary to the Sanggunian po yung nag-a-administer ng oath, ay mukhang baka magka-problema po tayo dyan. So as much as possible, doon po tayo sa ating mga elective officials, which is part of the sanggunian po yung mag-administer ng oath.
Sometimes po ako naman po yung nag-administer ng oath. Pero most of the time po is it's the FCB secretary.
So yun lang po, sir, as much as possible, doon na lang po sa ating presiding officer ng sanggunian mag-administer ng oath po.
Okay po, thank you po, sir.
Thank you very much din po. Yan. So, yun po. Next naman po tayo na naka-raise hand po si Sir Al Palamos po. Sir, you may unmute yourself na po. And may we know po, sir, from which LGU po tayo galing? Yan. Hello po, sir. Ayan po, they're just, for a while po, I think they're just, ano po, ayun, ay,
Magandang umaga po.
magandang umaga po, sir. From which LGU po tayo, sir?
Maraming salamat po.
Morning po.
Actually, sa tagal ko na sa munisipyo ay ngayon lang ako naka-ate ng ganitong seminar patungkol sa Quasi Judicial. Ang tanong ko lang, what is the extent of the police power of the Quasi Judicial body? Plainly kasi ang Sangguniang Bayan ay hindi pwede magpatawag kung talagang, halimbawa, meron nagko-complain, wala kaming police power sa kino-complain. Pero during quasi-judicial body, ay pwedeng, yun ang gusto kong kung hanggang saan ang extent ng police power ng quasi-judicial body. Thank you.
Thank you din po, sir. Attorney Irvin, Attorney Ram, you may answer po.
Attorney Ram, may ano po kaya?
Sige sir, ako muna. Pag kulang, dagdagan mo. Ang question po ni Sir Al ay ano po yung extent ng quasi-judicial powers, and na-mention po niya yung police power din. Magkaibang powers po yun. Yung powers ng Sanggunian in the exercise of their quasi-judicial function, clear naman po siya sa local government code yung extent niya. Una, to direct the respondent to answer the charges against him, to conduct investigation, to issue subpoena in order to aid them in the conduct of investigation in the event that the pieces of evidence submitted by the complainant and respondent is not sufficient in their evaluation for them to make a sound decision. Next, andun din po yung powers ng Sanggunian to impose preventive suspension, and eventually, if they found the respondent guilty, they have the power to impose that penalty. So wala po tayong, base po na rin sa batas, ay wala po talagang nakalagay na police power dun sa na nakakabit sa function ng Sanggunian. Kasi unang-una po, magkaibang function po yun eh. Yung police power, sa definition pa lang niya, agad na the power of the state to regulate the use of property, regulate liberty for our benefit. While the quasi-judicial function, meaning niya, the power to determine certain facts, and from that facts to draw a conclusion. So, hindi po siya talaga related, sir. Then hindi po natin siya talaga pwedeng invoke dun sa Sanggunian yung police power.
I see.
Magkaiba po yun.
Follow up ho, no? Paano ho kung yung kino-complain ay ayaw mag-cooperate sa patawag ng Sangguniang Bayan?
Sir Erwin, sige po.
Regarding po dyan, sir, kapag yung ating respondent po ay hindi po nakikipag-cooperate doon sa complaint na isinampalaban sa kanya, based na po sa na-mention kanina ni Attorney Mendoza sa kanyang lecture, is that yung taong yon ay mako-considered na wini-waive niya po yung right niya to defend himself doon po sa ating admin hearing. So kapag wini-waive na po niya yung, if it is already considered waive na po, if it already ang tawag dito, sir, kapag na-waive na, considered na po natin na waive yung kanyang right to defend himself, ay pwede na po natin i-continue yung proceeding sa ating admin hearing based doon lang po sa mga na-ipresentang evidence ng isang party without the answer po ng ating respondent. So pwede po yun, magdedire-diretso pa rin po yun hanggang doon sa decision natin.
Okay, last na lang po. Plainly lang, no? Ang Sangguniang Bayan, wala talagang police power kung ganun.
Wala po.
Sir, Regarding police power, sir, police power kasi, sir, is inherent. It is an inherent power po ng ating government. Siya po ay inherent power sa ating national government. Ang ating pong mga local government ay meron din pong delegated police power from the national government. Yan po ay delegated po ng ating local government code. Nakadelegate po yan based sa ating local government code. Mainly, sir, ang police power po talaga ng isang sanggunian is the legislative function. Yun po ay mainly to create or enact laws and resolutions for the common good of the for the common welfare po ng ating citizens. Yun po yung pinaka police power po ng sanggunian. On the side po ng quasi-judicial power, separate naman po kasi talaga siya because it is a power to hear po an administrative case against an elective official.
Okay.
Yes, sir.
Thank you. At least narinig ko na yung ganun. Thank you.
Thank you very much
sir. Thank you po.
Tapos si Councilor Al Balamos po pala ito from Santa Cruz, Marinduque po.
Santa
No?
Cruz po,
Tama po,
Santa
sir.
Cruz, Marinduque.
Apo, maraming salamat po for your question, sir.
Thank you.
Okay. So, ang atin naman pong susunod na nag-raise po ng hand ay from dito po sa ating chat box. Nag-raise po raising hand po yata ito from SB Mugpog po. Tama po ba? And nag-chat din po sila ulit na permission to raise question po. Councilor Orlan Milambiling from LGU Mugpog. So, sa Mugpog po muna tayo. Sila po yung ating sunod na nagtanong. You may unmute na po. Hello po. Ayun. Magandang umaga po.
144.
Chels, I think we posted the question on the chat box.
Sige po, we're just Coron po yata. Ito pong ating teka lang po. Reviewing lang rin po. So, sige po. Hello po. Narinig po ba kami ng LGU Mugpog po?
Has the power to prescribe regulations to promote the health.
Hello po, sir.
Wala pong audio sa Mugpog.
Okay po. So, akala ko po kami yung nawawala. Ayan po. Hello po, sir, sa Mugpog.
Wala pong audio.
Nagkaka-problem lang po yata sila sa audio. Ayan.
Next na lang muna siguro.
Okay lang po na balikan na lang po natin yung LGU Mugpog. Don't worry po. Balikan po natin kayo, sir, kapag ayos na po natin yung ating audio. Thank you very much po. Sige po, sunod po tayo sa LGU Coron po. Sila po yung ating next po na nag-chat and nag-raise po ng hand. So, meron po sila ditong na-chat po sa ating chat box, pero maybe they can also verbally share na lang po yung kanilang question or concern. Ayan. Good morning po sa atin pong LGU Coron. Taga dyan po si Attorney Irvin. So, guaranteed po tayo na maayos po ang kanyang pagsagot. Hello po. Ayan, kanina po ay nag-unmute na po yata sila. Hello po, sa LGU Coron. Sige po, habang inayos po nila yung kanilang audio, you may unmute na po now. Ibasahin lang po siguro natin yung kanilang na-chat na po dito. So meron po silang dalawang questions. Ito po yung una. Anong case po ba ang pwedeng patawan ng dismissal? O paano namin malalaman yung gravity ng desisyon na aming gagawin base sa administrative case na dininig namin? And then po, siguro po basahin ko na rin po yung kanilang susunod na follow-up question since related po siya dun sa kanilang original question na yun. Confusing lang daw po kasi with what having been discussed earlier na yung Sanggunian can order the removal of an erring elective barangay official from office as the court are exclusively vested with this power under Section 60 of LGU. In our IRP, our respondent found guilty may be meted the penalty of suspension or removal by the order of the proper court or disciplining authority, whichever first acquires jurisdiction to the exclusion of the order. So ang tanong po ulit, what to do po if one of the witnesses refused to receive the subpoena issued by the Sangguniang Bayan and bank for the conduct of formal investigation? So yun po, baka po pwedeng i-process po muna natin yung kanilang unang question, attorneys.
Attorney Raymond, sir? May ano po kayo?
Dito muna siguro ako, sir, sa last inquiry, what to do if one of the witnesses refused to receive subpoena. Based on your discussion kanina, the subpoena is a compulsory process, and non-obedience thereof, pwede pong mag-file ng appropriate petition in court yung body that issued the subpoena. But it is not the Sanggunian who will cite the witness who refused to attend in contempt, but it is the courts. So you will have to resort to judicial remedies if there is refusal to abide by the subpoena. Titingnan niyo po kasi doon sa last paragraph nun, laging may nakasamang fail not under the penalty of law. But you cannot be immediately penalized without resorting to judicial remedies. Yun po yung sa last question.
Yes po, may additional din po ako. Regarding po doon, kapag nag-refuse po yung witness natin doon sa subpoena na pinadala po ng ating mga sanggunian, unang-una po is based doon kanina sa ating discussion, is kung may power po ba to issue a contempt, is to cite a person in contempt for refusing to receive the subpoena. Ang sagot po natin dyan is malinaw po kasi sa ating local government code na hindi tayo binibigyan or hindi binibigyan ng contempt powers ang ating mga local sanggunian based po sa ating local government code. So it is safe to say that on that issue ay wala pong power to cite in contempt yung ating unwilling witness. However, ang sabi din po kanina is ay pwede po tayong humingi ng tulong sa ating RTC by filing an appropriate pleading. So yun po ay pwede po tayong mag-petition or mag-file sa ating mga local courts to cite that person na nag-refuse to receive the subpoena in contempt. So pwede po yun po yung pwede nating maging remedy on that situation. So dito po sa isang question na naka-provide po sa ating chat, if removal can order the removal of an elective barangay official from office of the court as the court are exclusively vested with this power under Section 60 of the LGU. So para po ito sa ating mga sanggunian, we have to abide by the words of the law. So ano po ba yung nakalagay sa ating local government code? Yung nakalagay po kasi sa ating local government code ay ang sanggunian ay hindi pwedeng mag-impose ng penalty of dismissals again an erring official. Clear naman po yan sa ating local government code. And if meron po kayong nakalagay po sa inyong rules of procedures that you can impose the penalty of dismissal, ay pwede po yung ma-declare na invalid or not in accordance with the law. Or if you will impose the penalty of dismissal, pwede po kayong magkaroon ng grave abuse of discretion sa pag-perform po ng inyong function. dahil clear na clear po sa ating local government code na ang penalty of dismissal ay hindi pwedeng ipataw sa ating mga local elective officials under po ng local government code. So, yun po, if gusto po nating magkaroon ng dismissal gusto mo nating mapadismiss ang isang official, ang meron lang pong power niyan is based na rin po sa mga rulings ng ating Supreme Court ay ang Office of the Ombudsman or by filing an appropriate case for dismissal po sa ating mga proper courts. Yun po yung ating magiging remedy if we are praying for the dismissal of a particular official. So yun po, I hope clear po yung ating sagot dun sa question po from LGU po ng Coron, Palawan. So good morning po sa inyo dyan sa pag-accept ng invitation po namin. Maraming salamat po.
Ay, okay po ba tayo? Na-satisfy po ba yung ating 2 main questions sa atin pong LGU Coron? Okay naman. Ayan. Baka yung Maraming salamat po. Ayan. Nag-chat po yung LGU Mogpog. Okay na daw po ang kanilang audio. So, balikan na po natin yung question naman po. Ayan po sa LGU Mogpog. Ayun. Okay. Magandang umaga po.
Okay, thank you po. Good morning po.
Ayun po. Ayan, very clear na po ang ating audio, sir.
Okay. Councilor Orlan Milambiling po, from Mogpog, Marinduque. Good morning po sa lahat ng members, lalo sa git ng PCL Marinduque. Marami ko pong questions. Bali 5, pero gagawin ko na lang pong 3. Sir, ma'am, number 1 question po. Kindly expound on the issue of forum shopping. Number 1 po yan. Yung complainant natin, forum shopping. Number 2, yung issue po ng inhibition, who will inhibit in the adjudication of administrative case. And number 3, if there is a tie in the decision making, if there is a tie, who will break the tie? Number 4, if the presiding judge, the vice mayor, inhibits, who will assume as the presiding judge? So yun po 4 na tanong po.
Yes, sir. Pwede sagutin ko po yung sa forum shopping po natin. Ang forum shopping po kasi, meaning niyan is yung isang tao ay nagfa-file ng case sa different courts. So, meaning, yung forum shopping na sinasabi is judicial courts. Hindi po siya quasi-judicial body. So, meaning, nag-file po kayo ng isang case sabihin na lang po natin, example, sa RTC, sa isang RTC, ay hindi na po kayo pwedeng mag-file sa isa pang RTC. Wala po kasing clear, definite ruling po regarding cases filed before an admin body or a quasi-judicial body and a court. So for example, nag-file po tayo kanina sa office of, sabihin na po natin sa RTC, mayroon pong case na i-file sa local Sanggunian, hindi po natin siya pwedeng sabihin na merong forum shopping unless nakalagay po sa inyong rules of procedure na bawal po ang forum shopping. So dapat i-define po ninyo sa inyong rules of procedure na ang forum shopping ay, for example, if already filed in Sanggunian, hindi na siya pwedeng i-file sa other courts. So pwede po ninyong i-define yun sa inyong rules of procedure. Pero as much as legally speaking, forum shopping is also a very technical word po siya na ginagamit sa ating judicial proceedings, na meaning you cannot file a different case for different courts by having for seeking one relief. For example, gusto nating ma-dismiss si ganito, pa-file tayo sa different courts. Hindi po pwede yon. Ang dapat po doon ay ay sa isang court lang talaga mapupunta yung ating case. Dahil meron din pong requirement ang mga courts natin na mag-issue po ng certification against non-forum shopping. So part po 'yun ng pleading na nagsasabi na walang case na i-file sa ganitong court, at dito lang sa court na 'yun merong ganun. So yun po yung ating ibig sabihin ng forum shopping. So dito po sa case ng ating mga local sanggunian, if our rules of procedures requires a certificate of non-forum shopping, ay pwede po natin ma-consider yun. I mean, if found po natin na nagsasampa-sampa lang kung saan, pwede po natin ma-dismiss yung case na i-file sa ating sanggunian. Yun po yung sa ating forum shopping. Tapos, sir, meron po, Attorney Raymond, meron po kayong
Okay na, sir.
additional po?
Okay na po ako.
Tapos dito na po sa ating inhibition rule. So if ever po na sabihin natin nearest relative po nung ating official na part po ng sanggunian, yung kino-complaint or kahit na po yung complainant, ay pwede naman po mag-inhibit yung isang member po ng ating sanggunian. Hindi naman po natin yan, wala naman pong prohibition ang local government po regarding that. Magde-depend na lang po talaga din yan sa ating rules of procedures. Kung ano po yung rule doon na nakalagay. For example, sabihin natin, kahit second degree of consanguinity, dapat mag-inhibit na si ganito pong official, ay mag-inhibit na lang po siya. If ayaw niya pong mag-inhibit, pwede naman po i-erase yun ng majority ng members ng sanggunian na ipa-inhibit yung particular official po doon sa admin case na hini-hear ninyo, na sabihin natin na pwedeng pwedeng maging bias po yung ating particular official on that. So sa inhibition po, hindi naman po siya prohibited. So pwede naman po 'yun. Go as long as magiging impartial po yung ating local sanggunian. So yung Attorney Ram, may additional po kayo?
Okay po, okay.
Addition?
Okay po. Yung number 3 naman po.
Opo, regarding naman po doon sa typo sa ating decision making. Ang ating po kasing ating quasi-judicial bodies, sanggunian, is ano po yan, ay dapat add numbers po tayo. Meaning, may isang magpe-preside, yung presiding officer ay hindi po siya kasama sa botohan. Siya ang magbe-break po ng tie in case po na mangyari yung tie na sinasabi niyo sa botohan po doon sa magiging decision. Yung presiding officer, siya po talaga, initially hindi po siya kasama sa botohan ninyo sa pag-decide ng case. In case po na magkaroon ng tie, doon lang po siya magbe-break ng tie. Yun din po ay depende rin po sa inyong internal rules of procedure kung ano po yung inyong rules regarding that. So for dito po sa ating last question, yung sa kung if ever po na nag-inhibit si Vice Mayor.
Vice Mayor.
Opo, or in case na wala si Vice Mayor, absent siya, or hindi po siya pwedeng mag-hear ng case, yung next ranking official po yung magte-take over. Kung sino po yung next ranking official. So yung first councilor po, siya po yung magpe-preside ngayon sa admin hearing po.
Okay.
Yun lang po, sir. Attorney Ram,
okay, thank you po.
Thank you po, Attorney Irvin. Attorney Ram, may additional remarks po ba tayo, sir?
Thank you po. Meron pong kasama ko, okay?
Camera.
Thank you po. Good morning po sa atin. Magandang tanghali. Consyal Mundoy Ola po dito rin po sa Mugpog. May dalawang question lang po ako. After an administrative hearing and rendering a decision, who has the right to make an appeal? The respondent or the complainant? Second question, can a decision rendered by the Sangguniang Bayan be overruled or reversed by the Sangguniang Panlalawigan without consultation or conducting a hearing. Thank you po.
So, doon po sa ating
Yes,
right
Ate
to
Gary.
appeal, opo, kung sino po yung pwedeng mag-appeal, depende po yan kung ano po yung magiging decision siguro nung sanggunian. If ever, yung complainant ay successful po siya sa kanyang complaint against doon sa nireklamo niyang official, ang may right po to appeal is yung natalong party. Of course, hindi naman na po kayo mag-aapela kapag kayo na yung nanalo doon sa kaso. Ganun din naman po if ever na in favor doon sa ating defendant or kung sino po yung inireklamong official, kung siya po yung nanalo doon sa admin case, pwede pong i-apela uli yun nung nag-complain. It goes the other way around po na kung sino yung natalo, siya po yung pwedeng mag-raise ng question. Kasi napaka-ano naman po na ikaw na po yung nanalo, i-aapela mo pa yung decision, di ba? So, kung sino na lang po yung deprived party, siya po yung pwedeng mag-appeal nung case. So, yung next question po ay paulit na lang po kung ano.
Attorney Irvin, yung pag-overrule daw po ng Sangguniang
The Sangguniang Panlalawigan reverse or overrule the decision of the Sangguniang Bayan without prior consultation or hearing. Ni-reverse po halimbawa ng Sangguniang Panlalawigan ang desisyon ng Sangguniang Bayan nang walang patawag man lang Sangguniang Bayan o konsultasyon. Thank you po.
So regarding po sa ganyang sitwasyon, sir, ay dapat po una, lagi po nating titingnan kung ano po yung rules of procedure nung particular sanggunian na yon. If ever na sabihin po natin na nakalagay sa rules of procedure nila na kailangan po makapag-answer yung sanggunian po sa baba, is masasabi po natin magkakaroon ng violation po ng due process. Sinabi na nga po natin kanina na importante po ang due process sa administrative cases. So if ever na ni-reverse po nila yung inyong decision without hearing anything from you, ay meron pong magiging violation doon, ay lalo-lalo na po sa inyong due process dahil you have the right naman din po to answer kung ano po yung inapela ng party.
Thank you po, Atty. With our rules of procedure na approve ng Sangguniang Panlalawigan, pero twice kami nag-conduct ng decision na in-overrule nila. Thank you po.
Sige sir, thank you po.
Thank you very much po sa LG Mugpog para po sa mga malalaman na tanong. So ngayon po dako na po tayo sa ating last question na po nating entertain given the nature of our time. Don't worry po, lahat po ng ating mga na-chat sa ating Zoom chat box and yung ating pong mga na-receive sa YouTube channel ay we'll address them na lang po through email ng ating mga attorney. So sige po, last po na question from LG Ugasa naman po. Counselor kay Counselor Isidro, sir. Magandang umaga po.
Hello po.
Ayan, hello po,
Hello
sir.
po.
Apo.
Narinig na po
namin
ako.
kayo.
Okay, magandang umaga po sa ating lahat, Ma'am Chel, Attorney Irvin, and Attorney Raymond. Good morning po. Councilor Joy Raymond Isidro po, dito po sa bayan ng Gasan, Marinduque. Sir, kahit sino lang po ang sumagot. So meron lang kami naging confusion kasi nagkaroon kami ng isang instances dito sa aming bayan, being the Committee on Laws and Ordinances. Ako po ang chairman at member din ako ng Committee on Barangay Affairs. So kadalasan pag may mga reklamo regarding sa ating mga elected officials ng barangay, kadalasan po ako ang nag-chair. Kaya meron kaming isang situation na isang barangay official ang reklamo ng kanyang kagawad hanggang nakita namin sa committee na merong merito yung kanyang reklamo. So naakyat siya sa Quasi Judicial at nagkaroon ng decision yung body na siya ay mabigyan ng disciplinary action sa pamamagitan ng 15 days suspension without pay. So binigyan namin ng kopya ang Office of the Mayor, ang aming DILG, yung barangay official na nagreklamo at nireklamo, binigyan namin sila ng kopya. But suddenly, kumbaga, nung naibaba namin po, di ba, yung decision, supposedly dapat siya ay for implementation na po, di ba po, attorney? So ang tanong ko po kasi, kanina yung last part nung kay Sir Raymond, nakalagay kasi doon sa slide niya na the mayor cannot veto pagdating doon sa action ng Sangguniang Bayan pagdating sa Quasi Judicial. Yun nga, medyo napag-alaman namin na di umano, wala akong kasiguraduhan kung binito nga yun ng mayor or hindi na-implement kasi as per dun sa complainant ay hindi naman siya kumbaga huminto sa pagpasok, continuous pa rin. So parang na-neglect yung aming naging desisyon dun sa pangyayari na yon, yung aming hirap ay na baliwala. Ang tanong ko, sir, ay paano yung mga ganong instances na mga pangyayari?
Yes, sir. Kumbaga ang nangyari po is hindi na-enforce yung decision ninyo. Tama po ba?
Opo, parang gano'n na nga po.
Yun po, based po dito sa discussion natin kanina, lalo sa lecture po ni Attorney Mendoza, na dahil hindi po ito legislative function ng Sanggunian, kundi ito po ay under ng quasi-judicial function po ng ating mga Sanggunian, ay hindi po pwedeng ito i-veto or ipasawalang bahala po ng ating mayor na siyang dapat na mag-execute ng mga decisions na na-render ninyo as local Sanggunian. So, ang pwede pong mangyari dito is that yung respective official po na yon na sinabi nating hindi nagawa ng aksyon yung inyong decision, ay pwede po siyang isang maging ground din po for the violation of his functions. So yun po yung pwede nating maging considerations. May additional po kayo, Attorney Raymond?
Sir, wala naman po. Agree naman po ako dun sa comment niyo, sir, na the implementing authority, which is in this case the part of LCE, must ensure that the decision of the SB must be duly implemented kasi duty po nila yun.
Okay. Thank you very much po. Pero ang ibig ko pong sabihin na attorney ay wala naman akong direct information o direct validity kung binito ngayon ng aming chief executive. Yun nga lang, as per dun sa complainant, ay hindi naman kumbaga na-enforce yung suspension, yung disciplinary namin na action na ginawa ng Sanggunian. So yun lang po, naging confusing lang kasi nung hindi niya kinomply yung aming desisyon, so parang inano na lang din namin, hindi na rin kami kumbaga nag-push through for any actions. Basta ang importante pagdating dun sa aming sa Sanggunian at dun sa complainant ay nabigyan namin siya, yung ginawa sa kanya ay nabigyan namin ng hustisya at within the powers of the Sanggunian, ginawa namin yung aming trabaho. Yun lamang po. At thank you very much po. Thank you very much po.
Thank you, sir.
Thank you very much din po, Councilor. So, ayun po, no? Maraming salamat po sa lahat po ng active participation and very malalaman nga po na tanong. Mas nagbunga po ng maayos yung ating discussion dahil po sa inyong mga katanungan. So, at this point po, gaya po ng nasabi natin kanina, ay will park po yung ating pong mga nakalap. Dinocument naman po natin yan, lahat po ng ating questions and follow-up questions na natanggap. Pero at this point po ay bigyan naman po natin ng masigabo talaga na round of applause ang ating dalawang attorneys para po sa napakalinaw po ng mga sagot doon sa ating mga katanungan. So ayan po, pwede po yung party react o yung heart react kung ano po ang mas nais nyo pong ibigay sa ating mga attorney. So maraming salamat po ulit, Attorney Ram, Attorney Mendoza, and Attorney Irvin Palangka po. So at this point po ay dadako na po tayo sa ating closing program ng ating activity ngayong umaga. So before po tayo magtapos gusto lang rin po namin yan po, logout po ito, logout forms. I-chat po sa ating chat box. Pakipili na lang po doon sa choice yung logout. So ito po ay prerequisite po para makakuha po tayo ng ating certificate of completion and or participation para po sa ating activity. So kindly ensure na lang po na piliin natin yung logout doon po sa ating attendance form and i-accomplish po natin siya hanggang dulo. So habang ginagawa nyo po yan, we'll proceed po sa ating closing ceremony. So next slide please. Kapag po nagawa natin yung ating attendance form ay magagawaran po tayo ng certificate of completion. So i-email po namin ito sa inyo pong mga na-register po doon sa ating attendance form. So very important din po na working email po yung ating mga nailagay doon sa ating attendance form. Diyan po namin isisend din yung link ng recording ng ating whole session for this morning as well as yung ating materials po. So at this point ay uploaded na po dahil tapos na po yung ating sessions. Uploaded na po doon sa link ng drive na binigay namin kanina yung ating mga materials. Next slide please. Of course, para naman patawan ng nararapat na pagpupugay ang ating dalawang butihing resource speakers ay ginagawad po natin itong Certificate of Appreciation kay Attorney Raymond Alvin Mendoza, Legal Unit of the ILG Mimaropa for sharing his valuable time, knowledge, and expertise as resource speaker during the conduct of capacity development on quasi-judicial functions of the Sanggunian held on October 28, 2021, given on the same day, and signed by our Regional Director, R.D. Wilhelm M. Suico, CESO 4. So, bigyan po ulit natin sila ng palakpak. And of course, ayan po. Thank you po, Attorney Ram. Maraming salamat. Yay! Okay, next po, the same certificate is awarded to Attorney Irvin L. Palangka. Member din po ng ating, officer din po ng ating legal unit from the LG Mimaropa for sharing his valuable time, knowledge, and expertise as resource speaker during the conduct of our activity today. Signed also by our Regional Director, R.D. Wilhelm M. Suico, CESO 4. So congratulations. Okay, maraming salamat po sa ating, ayan, okay, nagta-thumbs up po si Attorney Irvin. Para naman po bigyan ng nararapat na pagtatapos ang ating pong makabuluhang discussions, no? Lalo na po, it talks about accountability po talaga and public service. Walang iba po, no? Ang aming hinihiling na makapiling para po sa ating closing remarks at aming Assistant Regional Director, si ARD Ray S. Maranan, CESO 5. Magandang tanghali po, ARD Ray. Ayan po sir, you may unmute na po. Okay na po sir.
Alright.
Ayun,
Magandang tanghali, Ma'am Chelsea.
Magandang tanghali po.
Ayan, magandang tanghali po sa lahat. Okay. Parang kulang ang ilang oras, ano? Mga kasama natin sa local government units ng Mimaropa. Parang kulang ang ilang oras nating pag-uusap tungkol dito. Alam natin na marami pa tayong gustong maitanong at alam naman natin kayang-kaya yung bigyang kalinawan at kasagutan ng ating mga speakers. Subalit ang ating oras ay hanggang dito na lamang at sana mayroon pa tayong mga future na paghaharap uli. But para sa formal na pagtatapos natin, ay dalawang bagay lang naman mula sa ating pamunuan ng DILG. Una yung appreciation, and then secondly yung prayer. Appreciation sa ating mga speakers. Thank you Attorney Raymond Alvin Mendoza, Attorney Raman Tami sa kanya. Si Attorney Ervin Palangka, our very own from Coron, Palawan. Thank you sa inyong expertise. Napakahusay ng inyong delivery, napakahusay ng inyong paglalahad ng presentasyon, napakahusay ng inyong pagsagot sa paglilinaw sa mga naging katanungan. We thank you so much sa inyong efforts. Kulang ang plaque o yung certificate para magpasalamat kami. Nandoon yung aming taus-puso, ang everyone here na pasasalamat from their hearts sa inyong pagsishare ng inyong knowledge and expertise. Sa support staff, of course, the LGCDD, the RIC, yung aming Capacity Development Division, ang aming RIC2 o yung aming information, yung aming isang division dito na nangangasiwa ng Information Technology, LGMed, nandiyan, Monitoring Evaluation Division. Sino pa bang nag-involve natin na support staff? Thank you sa inyo. Pag-handle ng flow at paano mangyari itong activity na to. Thank you sa inyo. Sa management for giving the all-out support para sa activity na ito. We thank everyone. And of course, sa ating mga participants from the local government units, mga vice mayors natin, mga sanggunian members, ang ating mga itong mga SK kung meron tayo dyan, Liga, IPMR, and staff kung nakikinig din sila dyan, everyone na naging bahagi nito, naging kalahok, we appreciate your presence here. And of course, ating mga field officers nakikinig din at nag-facilitate na maka-attend ang ating mga inimbitahang mga participants. Thank you sa inyong efforts. This activity is for a selected LGUs lang sana. Attorney Ervin, Attorney Ram, because di natin makater yung buong 78 local government units ng Mimaropa. But kaya pili yung mga talagang naimbitahan natin para dito because we see na ito maging series sana na this is episode 1, ito muna, then hopefully episode 2 with ito naman mga LGUs na to. But then alam natin magandang subject matter, other LGUs came to know na may ganito activity and they were able to be on board na rin dito. Kaya okay lang yan, open and learning sa lahat. And everyone who wants to understand and know things ay open natin, and that is why hindi lang itong mga selected LGUs ang on board natin. As far as Cagayan Silio, sa ating mga taga-Occidental Mindoro, Romblon, every province ay well represented here sa ating activity na ito. Kaya welcome and learning to everyone, and we thank you for being on board. Sabi rito sa objectives natin, and we would want to ask you, this activity aims to reorient and capacitate the Sanggunian in the exercise of its quasi-judicial powers as provided in the local government code. Nangyari ba ito sa atin? Na-reorient ba tayo at na-capacitate ba ang Sanggunian natin para malaman na itong ating mga nilalaman ng local government code? Lalo na doon sa procedural and substantive aspect. So if so, congratulations, yung ating objective na-meet. And at the end of the activity, our participants are expected to have a deeper understanding regarding their obligation to act with utmost impartiality, integrity, and most especially the observance of due process of law in adjudicating administrative cases involving our local elected officials. Nangyari ba ito? Yung ating expectation ba na magkaroon ng deeper understanding ay sa mga bagay na ito ay nangyari? If so, thank you so much. Naging matagumpay ang ating activity na ito, and because of the gains that we have generated, nagpapalakas ng loob sa atin na gawin pa ito para sa iba nating mga kasama sa ibang local government units na hindi naging bahagi ng ating araw na ito. So from the foregoing discussions, but before that, I was able to go over this certain fact or information. We have 3 crimes, general in nature, crimes committed by our public officers like us under the revised penal code. May 3 daw na crimes na pwedeng makomit ng public officials under the revised penal code. And what are those? Sabi dito, non-peasants, general category, non-peasants. It is the omission of some act which ought to be performed. Hindi mo ginawa, dapat gawin, hindi mo nagawa, non-peasants, meron na tayong liability. Mispeasance, it is the improper performance of some act which might be lawfully done. So, mali ang pagkagawa natin sa mga bagay na dapat maayos sana ang nating i-perform. May liability pala tayo. So, hindi natin ginawa, merong improper performance, may liability tayo. And the last thing, aside from non-peasants and mispeasants, malfeasance. It is the performance of some act which ought not to be done. Sabi nang wag mong gawin, ginawa mo pa. Talagang may intention kang masama. That is malfeasance, may liability tayo doon. So hindi mo ginawa, mali ang pagkagawa mo, hindi mo dapat gawin, ginawa mo, everything may liability tayo. So ang hirap gumalaw, ano? So sa daming dapat natin gawing tasks, i-perform na duties, functions, responsibilities, most likely may makukumit kang alinman sa non-peasants, mispeasants, and malfeasants. But as long as that you have acted these things in good faith, ang pinakamasama niyan ay for your benefit. Kaya ginawa mo to, may interest ka, yun ang hindi natin o mahirap natin i-justify when reckoning comes in the eyes of law, in the eyes of the Lord. Hirap. So those 3 things hopefully ma-avoid natin. The non-peasants, the mispeasants, and the non-peasants, and the malfeasants. Okay. So from the foregoing discussions kanina, we are listening intently, although may mga times na we have to listen to the other thing we are attending to because may meeting from the Office of the President, National Task Force on LCAC, because may presidential visit on November 4 sa province of Palawan and on November 11 sa Calaptan City in Oriental Mindoro. That's why we are preparing for that. Nagmi-meeting kanina ang OP with the other agencies. Kaya we are on board there. But we are trying to listen dito sa mga discussions. So from the foregoing discussions regarding the capacity development activity, we expect that we were able to have a deeper understanding of the significance of this very important non-legislative function of the local Sanggunian, and that is the quasi-judicial. It is a great responsibility and a privilege to be given quasi-judicial powers under the local government code to exercise disciplinary action over erring elective local government unit officials in case ng ating Sangguniang Bayan over our barangay officials. At tayo naman sa Sangguniang Bayan, Sangguniang Component City, Sangguniang Panlusot, sa Sangguniang Panlalawigan. It is a fact, in fact. And have you not noticed that it is not the DILG, it is not the department which was granted this authority by our laws, but the local Sanggunians. So yung quasi-judicial functions ay vested sa Sanggunian and not the DILG na mag-resolve ng cases, administrative cases over our local elected officials. So ang power na ito binigay sa inyo mga Sanggunian members. Our primary function sa DILG is merely general supervision over LGUs, but not the power to impose sanctions over erring local elected officials. Our prayer then, given na pinipilit natin, tinatry natin na makapacitate ang ating mga local officials, and this is one of the things we are doing, we have done. Our prayer then is that we hope that after this learning session, our Sanggunians, our participants here, will be able to exercise their power to discipline or impose sanction in an impartial but swift manner. So impartial but swift. So tayo may timeline na sinusunod. Bakit nagdadrag? Bakit tumatagal? May issue ba ron? But then we are supposed to discipline or impose sanction supposedly in an impartial but swift manner so as to immediately fulfill our mandate to administer justice and exact accountability. However, let us not be overzealous or eager enough in the exercise of disciplinary powers natin, this big or great power. Let us not be overzealous or too much eager. We must not forget our primary and basic right to due process of law, a constitutional right guaranteed by no less than the Philippine Constitution. Observance of due process of law is one of the essential elements of a democratic state wherein the rule of law always prevails over the rule of men. Lalo ang sanggunian, political. Bakit may decision na tayo na overturn ng higher sanggunian na panapil? Because po maaaring may mga dynamics, but then the rule of law should always prevail over the rule of men. Due process of law in many rulings of the Supreme Court states that it is a law which hears before it condemns, which proceeds upon inquiry, and renders judgment only after trial. Due process is satisfied when a person is notified of the charge against him and given an opportunity to explain or defend himself. Our last prayer would be, it is so that in the exercise of our quasi-judicial functions, let impartiality and due process be our guide in demanding accountability and to ensure that justice is rendered within the bounds of law. Our final salutation would be, we have read Stephen Covey's book, The 7 Habits of a Highly Effective Leader. Meron siyang binabanggit na isang habit doon, the last habit, number 7, and that is, we all know, sharpening the saw. So meaning, let us continue attending seminars, attending capacity development activities, and the DLG has an obligation or responsibility on this as we would continue to offer our learning sessions hindi lamang sa Sanggunian, kundi para na rin sa ibang mga functionaries natin, sa local government units natin. So we will be trying to make this a series na nakita natin ang importance of providing learnings and appreciation on the part ng ating mga learners. Kaya let's try to continue attending these learning activities. Let's try to continue reading important resource materials such as our DILG issuances, our DILG circulars, our legal opinions, other government policies issued by the national government agencies, our court rulings, and many other resource materials, because it would always be important na mas nalalaman natin ang iba pang bagay na hindi na ituturo sa atin formally through a training activity, a capacity development activity. So there are many ways of learning of how we could always be sharing ourselves. So sa lahat na naging bahagi ngayon ng ating activity, on behalf of our dear Regional Director Wilhelm Suico, ang ating pasasalamat sa lahat ng naging involved, naging bahagi, lalo-lalo na sa ating mga nagpunyangi na mangyari ito, naging participants and everyone. Good day, everyone. Great day ahead.
Thank you very much po, ARD Ray. Isa naman pong masigabong palakpakan din po ulit para sa napaka-meaningful po no, na closing remarks para sa isang mahalaga ding usapin na napagdaanan natin ngayong umaga. So maraming salamat po, ARD Ray, and thank you so much everyone. So meron lang po kaming official announcement. So meron lang po tayong oversight dun po sa ating log-in and log-out form. So we'll be coursing through na lang po sa aming mga provincial focal persons and sa ating pong mga field officers yung corrected survey link po or survey content. So don't worry po, hindi naman po mawawala yung ating mga entries. So we'll also email po para po dun sa mga nakapag-login and ma-receive nyo po yung inyong certificate of completion. Thank you everyone, and don't hesitate po to reach out to the contact details po flashed on your screen, and we'll be addressing through email na lang rin po yung ating po mga nakolektang capped questions kanina. And of course, don't forget to like and subscribe yung amin pong na-share na YouTube link dito po sa ating chatbox kanina. Yan po ang official YouTube channel ng DILG Mimaropa LGCDD for the latest and greatest CapDev content. So, sige po, next slide po. Yung ano po, contact details slide. Ayan po, basta you may reach us po at our official email address po, dilgmimaropa@gmail.com, and through our official Facebook page po, DILG Mimaropa Region. Sige. Okay po, muli po, maraming salamat at ingat po tayong lahat.
Drop it.